Wait, please, Lordship. Lordship, I beg to mention item number 4 and 5, Lordship, with the permission of the respondent side, Lordship. Yes, Lordship, but here, Lordship,
We can't keep it so long. And we have to release it. Why,
Lordship,
John? Why do you want the matter to be adjourned?
Lordship, actually, this matter is argued by Mr. Narasira, Mr. K.K. Mohanto, sir, Lordship, but he is in operation I have heard, Lordship.
So it's very difficult to constitute the bench.
Yes, that is correct, but
Which is represented on the pair mechanism says how. Which is represented on the pair mechanism says how plan for the. Respondent, the matter stands adjourned today. Next paragraph, it shall not be treated as a patent matter. List after a week on a date to be fixed by the registry. Next paragraph. It is hoped that on the next date of listing, none of the parties shall pay for an adjournment.
May I pay for a fixed date?
Fixed date, you see, we are taking at a fixed date, we are constituting a bench for this, or for a fixed date, and what has happened?
It was lastly fixed on 30th of this month.
No, we are sorry. You make a mention before the appropriate bench.
We
Will be taking up. No.
I am for the appellant and we are.
You see, what is the point? We don't get an advance information. We see the files come back, is a patent matter.
Yes, sir.
And then matter gets adjourned.
We have not taken judgment in this case.
No, that's okay. Make a mention before the bench.
Okay.
Bench will take it up as per its convenience.
Because
The bench which is taking up will take up
Yes.
its convenience. I can't direct the bench to take up on a particular day.
yes, sir.
I can bind myself, but I can't give a direction to the another bench. To take up on
If
another
matter is
fixed date.
not released, then maybe fixed after, in a fixed date or after 2 weeks, Lord.
They're not doing it.
Because it was last.
You can always make a mention before the bench.
Yes.
Make a mention, we will not direct the other bench to take up on a particular day.
Lordship, can I, Lordship, wait for a list of 2 weeks, Lordship, otherwise in this time, Lordship.
We are not fixing a date. You have heard us.
Yes, Lordship.
If you want it to be heard, you start your argument today, now. You can dictate the court that do this, do that. It was a fixed matter, you knew that it's a patent matter.
Yes,
Yet you are taking an adjournment. Why make us read the files? Why make the registry constitute a bench then? And when we say it harshly, then you will go back and then say that the court was not kind enough to make to say what do you call to say it politely. You don't deserve a politeness. You could have told us yesterday that on a circulation that don't read the files. You don't have that much of courtesy.
No, like,
And then you insist for a.
Yesterday I came, Lordship, I informed by, yes, yesterday I informed.
Without memo, will the court master dictate me to take up the matter and do not take up a matter? You don't have that much of courtesy.
Sorry for that, Lordship.
Yes, pleasure, Your Lords. Also, in item number 2, we have circulated adjournment.
Item number?
Item number 2. That the arguing counsel is not available, Your Lordship. She is out of station.
Good. Okay. The prayer made by both sides of the prayer made by the counsel to petitioner. Matter stands adjourned today. List after 2 weeks on a date 2 weeks is by the registry.
I'm obliged.
Daily list item number 1 for orders, part third matter.
Grateful to Lordship. Lordship, this matter is led by Mr. P. Nayak, addition AG Lordship. There's some difficulty in the first half, Lordship. I pray that the matter will pass over for the time being, Lordship.
For the time being, is this anytime when Mr. Nath stands up,
Lordship,
there's always a difficulty. Why?
Lordship, at 2 o'clock, if it's possible.
Hmm?
At 2 o'clock.
2 o'clock, we won't have this bench.
She has a few items open.
Only few items. It's constituted only for this matter.
Lordship.
These 5 or 6 matters. We don't have any other patent or matters tied up with us.
Lordship, first half, it will be difficult,
Hmm?
Lordship, first half is.
No, then we'll hear this and dispose it off, because it can't happen like that. Every time it can't be adjourned. Parted matters, we find it very difficult to adjourn. We may have difficulties, but we have difficulties also.
Lordship is not in court right now, Lordship.
Please try to understand, if it is parted, we carry with it a lot of luggage with us. We are not of free mind then. We can't help it. Parted matters, we are not adjourning on a drop of the hat, no. We'll wait for some time, it doesn't come, then we start the hearing.
Lordship. Deeply punished.
For orders. Item 3.
Lordship, we were just discussing, it's not easy.
That's right, not easy.
The other day we were in Justice Amanullah's court. Even Supreme Court has now started sometimes having 100+ matters. And there was a sense of deja vu between what you were saying and what we heard in that court.
At times we can't.
In some of the courts, here also in Gauhati, in Delhi also, now it's becoming that if the senior is not available, you argue. Unless there's a prior adjournment.
No, you see, the difficulty of us is that once it is parted, we have to carry some luggage here.
No, it's a lot of baggage. Achha, we also asked for partner. Yesterday I asked before a judge, he said, no, I'm not. Nalin,
No,
we don't carry this baggage further to the next roster.
always have to keep the notes ready to reconnect from where you have stopped. You have some difficulties.
So therefore, that's why we were just saying, the sense of deja vu. Recently, we just seen something in the Supreme Court. And my friend also had to guide me. No, this time you're on the other side. If I may, Lordship, it's a short point. Lordship passed the judgment. In that judgment, Lordship passed certain directions in para 140. Those directions the state has implemented. Some people have taken the challenge to the Supreme Court, which is being heard in August, I think the next date is. Some have filed a review. Lordship has already issued notice also in one review petition. Of course, that is on a larger. Now, let me come to the state. Ours is an extremely limited and narrow review.
Since we are hearing all the matters, the respondent is not appeared. You give a notice to the other side?
We've done that. It's coming first time, Lordship.
No, but in an appeal, it's an extension of the writ petition. The notice.
It's a review, Lordship.
That's what I'm saying. A review is an extension of the
That is
main writ petition. So order 3 permits 3-4, I think. It permits the lawyer to appear in the matter in review.
But if I may just only, Lordship may issue notice and they can, of course, respond. Ours is, and just, I'll take no more than 30 seconds. I don't want to burden Lordship and Ladyship's board today. Our point is limited only to one thing, para 67, 68, because the statutory rules were never under challenge. And our concern is that because there are findings on the statutory rules, they have a cascading effect. There is no other review in our sense. So it's to the limited point of the statutory, para 67, 68. And Lordship actually has upheld the statutory rules in para 55 also. Yeah, so Lordship had actually introduced 3 conditions in para 67 in terms of it. Those conditions, according to us, are beyond the statutory rules, and the statutory rules have never been challenged. That's the crux. So if Lordship issues notice, there are in fact what we have not filed all of them. We have filed a review in each one of the 5 services. 6 services. This is excise like that. So if today once Lordship notice is issued, then the others will get tagged, and whenever Lordship hears it, we can hear it at that time. In APS, Lordship has passed an order, Lordship, on 19/3/26.
Review.
In review, Lordship. That is in review petition 41 of 26, Pallavi Sharma. Mr. D.K. Mishra had argued it at length.
Mr. L. Kohli, Senior Counsel, assisted by Mr.
Ankit Roy, Nimisha Menon, of course, Dipankar,
this
and that
is-
is our permanent.
He'll put it in.
He'll put it in.
Then Counsel, first it will be additional Senior Government Advocate, Mr. Nath, and then the Counsel. Next para. This review petition is directed against the judgment and order dated
25.
judgment and order dated
2006.
2025, passed by this court in WA 335 of 2023. In respect of a part of the order which is contained in paragraph 67 and 68 of the said judgment and order. Next further. In view of the issue involved, the court is inclined to issue notice returnable on. What is the last date in that case?
There's no last date, but we can share with Lordship. The order is 19/3/20.
It doesn't have a date.
It doesn't have a date.
Okay. Returnable on, give a date after 4 weeks, after vacation. Returnable on so and so. The applicant shall take steps within 2 days for service of notice on the
To the council.
Respondent by speed post is AD. In addition, copy of the memo of appeal with inclusions be also served on the learned counsel who was appearing for the respondent in WA 335 of 2023. And shall be acknowledgement before the registry. Next para. List on so and so.
Wait for it. July sometimes, August, whenever.
17 July.
That's an important date in my family. My father's birthday, so I can't forget that date.
Not that day. Somebody.
It's okay, Lordship.
It's
17.
okay. 20.
20 is wonderful. Grateful. Now, Lordship, while I leave on a complete non-submission this, let me lighten the mood. Recently, Lordship, I have a rock band of my own.
Is it?
Yes, Lordship. I'm the lead singer of that. It's an old college fancy that 3 years ago I started.
I don't know. The problem is that now sitting here, we can't ask for a complimentary card.
And Lordship, I can't seek your mobile number either. It has gone viral. Yesterday, in fact, it has got Republic TV has carried it, and Times Now here, Northeast Live carried it, Prague News carried it. Imna along, it's become like mega viral. So people have not used to seeing the other hat of mine carrying a hat of a rock band. So, but someday, Lordship, maybe in Gauhati we perform. We'll have the pleasure of Lordship and by the way there.
Yes, yes. Yeah, that will be wonderful to have to see the talent.
Of course, the bar would be of a different nature there. You know that, Lordship, the good old phrase, one of the Doyens, he was then the AG, I think, he had said, na, that without, what is the bar? I will share that quote, I'll write it on a paper and leave it. It's a very, very famous quote that with regard to the bar and the bench. So I'll write it down. In fact, the other day we were quoting it in court and having a little, Justice Kaurav in Delhi High Court had reminded us of it. I'm grateful. Lordship would like to tag it also, both the matters together. That's review
No,
41.
not now. Because then what happens
We'll
is
need to
that for
completely
service,
different rules.
not that. Once the service is not complete, every matter gets delayed.
Okay.
Once it is tagged.
Whenever.
So let the service be complete and then we'll tag it.
We are there, Lordship, for yours. Grateful, Lordship. Ladies.
Yes, Mr. Nath, you can begin your side. So that is the only matter we have now.
Yes.
virtually, on last occasion, I have concluded my argument, and thereafter he has produced certain documents. In last occasion, Lordship, kindly see the last order.
Just
Lordship.
give us 2 minutes.
Yes.
Time being item 1.
Just before I go to this. Last order, please. Last order. You can information, please. Lordship's last order dated 26/3/26, my lord.
I just recap of the day.
Yes.
On 21, there was an application for VRS. It was picked up on 24/12/2021. On 27/12/2021, it was forwarded to the Deputy Commissioner, Gauhati. On 27/12/2021, file was forwarded to ADC for comment.
It is his submission
That's right.
on this sheet. Yes. 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 Yes.
And then on 24/1/2022 by the EDC. DC approved on 9/2024 that we are application and communicated on 28/2022 that we have to the Interior Officer. 11/3/2022, I was put up for cycling of retirement benefit on 14/3. Still one for CRG.
Yes. 9/3.
And five. Then whether the fixes of 25/20.
Yes.
Your 21/12/2021, the letter requiring VRS data completed 20/12/2024.
Yes. This is the background. Now, last time I made my submissions, my lord, I raised 3 points. In fact, my argument has got 3 points. Number one, assuming filing of application of VRS filed by me on 20th December 2021 is correct. Assuming in page number 40, my application for VRS is correct. I made submissions, my lord. There are 4 judgments of the Honorable Court. In the VRS application, one shall have to mention the period of 3 months. 4 judgments I have given, my lord. Justice D.N. Barua, Justice Kritesha Singh, Justice Patnaik, then division bench, Dinesh Sangma case, then another one I have given, my lord. 4 judgments, 5 judgments I have given, my lord. Period must be given there. Otherwise, this void ab initio. Now, there is one judgment by Honorable Single Bench of this Honorable Court, Honorable Justice Shimon Shah, my lord. He has referred those judgments, but at the end, he opined that, my lord, period, if you don't mention also, automatically after 3 months, there will be arrest, but granted. But that is, according to me, Lordship shall have decided on these points because 5 judgments on one side, 1 judgment on one side, 5 judgments says, my lord, no, period must be mentioned. Otherwise, that is not at all an application under section 56C. First point.
This is reference to which letter?
That is letter dated page number 40. Dated 20th December 21. Just let me read this letter, my lord. Lordship will find another thing here. Because my appointing authority is deputy commissioner. If I have to file an application for BRS, it has to be my appointing authority. Here, my entire allegation is by force they came and they have forced me to put signature. That's why I see the heading page now 40. It is addressed to the treasury officer. And to the treasury officer. Gauhati on 20 December 2021. Yes. And in the rules, my lord, 56C, appointing authority, the appropriate authority means the appointing authority, my lord. In the rules, 50 lordship has seen last time, remember, my lord.
Just remind us. You said that the application for BRS should contain 3 months notice.
Yes.
That's the mandatory.
Yes. Because
I did not give that. And the authorities, when they take up these, they say that this is accepted as a 3 month notice. So what is wrong in that?
that is what,
This is much.
yes, but there are those 5 judges, my lord, I have given. The specificity is no, you shall have to give a notice of 3 months. Otherwise, it will be had. It will be out word of issue. That is the judgment Justice Jane Board was very clearly specifically stated. And also Justice Kutesh Singh, also Justice Patnaik, and also division based Dinesh Sangma case. And there is a single, there's one single case. I have given the judges. I have got with me. That's why I'm not saying, my lord, lordship kindly examine this and pass judgment, because it is not only for me. Future days to come, my lord, we'll know what do we stand, and when I make my submission next time, we'll make a proper submissions, and people will get relief accordingly, my lord. It's not that only lordship is hear me and pass judgment. No, whatever is right, my lord, justice will prevail, my lord. That's what. Immaterial whether I win or he wins, my lord. One of the citizens will win only. That's all. But law should be treated right, my lord, because this is number one. Number two. Lordship is 56C. Yes. An appointing authority means also the appointing authority. Here, my appointing authority is deputy commissioner, my promotional authority is deputy commissioner, NXR 1, 2, and 3. All these things, my lord. I put nothing to do with treasury officer regarding the appointment is concerned. So there also, my lord, lordship will, my lord, if your lordship is referring again and again the Nazir Ahmed case, if certain 1936 PB Council 80 years back, my lord, I don't know how those judges, they could visualize, my lord, after 80 years, what will happen? Their judgment still today previous, my lord. 80 years back to us, but it says, if certain things is to be done in a certain way, it shall have to be done that way, no other way. Now, if the rule 56C provides that it has to be by the appropriate authority, my lord, who is the appointing authority? How come this treasury officer also? This is also one mistake. Second mistake is, my lord, 3 months notice. Both of they're absent here. Now let us go to the next page number 42. My debt PRS application, withdrawal application. Original. My lord is here. This is the original actually. When I submitted the BRS application, I received copy from an Ojit Hazarika. And in my paragraph, page number 103 of the affidavit, page 103, it is there I have stated. They say, no, it was not received. I said the Ojit Hazarika, he and me, like the we are sitting here, years together, I sit together in the office. I know it's in writing. If there was no system, somebody comes, my lord, always there was a system. They put a signature initial at the beginning. There's no sealing system, putting the seal. It was not there. But now, they've started after this case now, my lord. Now, kindly see the original one. This is the recipient Ojit Hazar. Now, when I have placed this in page number 103 in the affidavit, subsequently they produced the record, but Honorable Singh as a hell, they have not denied that. Second page, Lordship, kindly. This is also a very short initial there. And now, my learned friend, my lord, Mr. Nayak has raised one issue. In that paper, my lord, my name is there, but signature is not there, he said, my lord. Kindly see the second page. My signature is not there. But this is my lord, this is not a fine copy. This is my own copy. That's what, my lord. This is my own copy. Just let me read once, my lord, what I've stated in my reply in the affidavit, my lord. I have written, your deponent denies the signatories that she was forced to sign the application dated 20/12/21 for voluntary retirement against her will, and immediately on the next day, this is on 21/12/21, page 103. She submitted the application to the respondent 4, the treasury officer, internally requesting him to cancel the above-mentioned application for voluntary retirement, dated 20/12/21, which was duly received by concerned Lord Division Assistant C. Ojit Hazarika on the same day under his own signature. It may be mentioned here in that your deponent used to sit in the adjacent chair of above-mentioned Lord Division Assistant Ojit Hazarika in the office, who used to receive official letters, documents on behalf of the respondent 4 by putting a short signature, and thereafter dispatches the same to the respective addresses. Now, Lordship will see, my lord, another issue here. In page number 89, page 84, an original handwriting is in writing note sheet. It's a register, my lord. It can see 84 and 89. Lordship will see that part. Once, let me show to your lordship. This creates a doubt. What happened actually? Now, kindly see page number 84. Lordship has seen that, see in the middle. There's a third, from the bottom third, page 84. From the bottom third, 20th December 21. Lordship has got it. Now, kindly see number 2464. This is the number they maintain in the office. Now, next number they have shown on 20th December 2021 is 2465. Two, 4, 6, but that lordship will find in page number 89. This is a type copy, and page 89 is 2464, and next page is not very clear, but it looks like 2465 left side, because next number is 2466. Then my learned friend, they have typed it in the page number 84, 28. Yes, correct. This is correct. Now, lordship, remember, my lord, I have given that last time calendar of 2021 December. 21st, 22nd, 23rd, 24th, office was open. 26th, 25th is a Christmas day. 26th Saturday. And 20th Saturday, Sunday. 27th was, my lord, working day. All these 5 days, there is no, lordship will believe that treasury office, as per this sheet, that sheet daily they receive, see the same date in 9/12, suppose. They receive so many documents. And all those days, there is no documents. The reason is very clear. The reason is, lordship has seen that one I have submitted on 21/12. It was received Ojit Hazarika. He didn't even know that day what is going to happen to this case. He doesn't know. He put it in the records. Maybe he made entry. Subsequently, they realized, oh, this is going to create a problem. So what they did, this is what they've made problem. That's why there are 5 days are missing. How can it be, my lord? 5 days missing. The treasury office, such a busy office. From their own documents, my lord, what happened? And I have given that calendar also. I found starts in the calendar, if I'm not wrong, probably.
That is, those put administration.
My lord. Now, kindly see the another point now.
At times you will find in my mobile. For 4 days, 5 days, I don't even receive my any call except from my account.
But normally, my lordship, mobile and our mobile, there's a difference. There's no, lordship, I've seen hardly, because lordship doesn't get even time to go all these mobiles now. I know, because I know your lordship, my lord. Or everyone, lordship, even lordship, my lord, you just count also. What is the time to go all these things? Now, my lord, kindly come to page number 55. See, now another blunder I'm showing, that committed. 55. Oh, no, please come to page 47 first. 47. 47. Let me read, my lord. This is by treasury officer to Binapani Datta. With on 20th of February 22. Please note down this memo number. Not only the last number, the full number. There's some reason behind it why I'm saying so, because last time it was checked up. Page number 47. Memo number, the full number. JT, my lord. Kindly see JT01.
That you have already made your
Yes,
submissions.
yes. No, I'm saying so. Why I'm saying stressing on this today. Last time I was stressing on 829. Although I said first part also. This number and the deprecation number absolutely same except 29A. That means this office file originated from the same table. Otherwise, suppose deputy commissioner is sitting in his office, treasury officer is sitting in another office. He moves a file with a particular number. It goes to the office of the deputy commissioner. He has got other number. He's got. He puts a number there. It goes
No,
back.
we don't know, because the fact is that in our registry, at times we have this dispatch person. So every file which is moved here and there will go to that dispatch, and
With
the
same
dispatch
number.
will give a number.
Number.
So if it is originates from my secretary, he will not give that number. He will merely say, for example, if it is this code, it will say KRS file number 2 and then sends it. And it is the dispatch.
Assuming this is correct, assuming this is correct, even though there's a problem. The problem is on 20, oh, kindly let me read this content. This is dated 20th February. With reference to the subject cited above, it is to inform you that the petition for voluntary retirement submitted by you on 20/12/21 has been approved by the authority, hence you are allowed to go. Who is authority? What is the memo number? Where is the date? Nothing is mentioned. That I have shown, my lord, on the day of motion when I moved it, my lord. And honorable court granted stay because of this, my lord. This one and then in order. Now, this copy, copy was not sent to anybody. It was given to me only. And this memo number, that is on 28/2/22. Now, please 55. The MP in order, page 55. That is the approval given by the deputy commissioner. That is on 9/2/22. Page 55. Nine to 22. Based on the report submitted by the DDO, Treasury Officer, Gauhati, a prior petition for Srimati Binato seeking BRS has been approved. And that number top is 829A. Cannot be, my lord. This cannot be. Maybe other lordship I agree, my lord. This I find difficult to digest. Cannot be. Because this is the relationship with the entry within the register. There's interpolation, double handwriting, overwriting, everything is there. I'll show. Yeah, once again, I've got the original copy which is given to by the register on first and RT application. I've got this one. But last time, my lord, in single bench, the entire bunch was produced. Single bench has produced that. I think this time he has brought this bunch photocopy. Your lordship may verify from get those original copies. Because I remember that. Now, see, my lord, this copy, order by approved. Now, see, only copy the treasury officer in all my appointment orders. Various officials, my lord, copies were sent. Here it was sent to only the treasury officer. And kindly see the memo number also. That's what I said, my lord, approved. After this, that page 47 improved order was passed, 28. My lord, this memo number now. Lordship, please come to page number 129, and it starts in page number 125. 125, please come. The heading is there. Register of letter issued. The heading is 125. Yes, yes. Yes. Now the relevant page is at page number 129. And I have given the, my lord, the clear copy, which I have got through part of the RT application, my lord. This is the copy. Lordship, can you have a look at this? This will give a better picture to your lordships, my lord. Now, 129 page number. It will be last page, I think, my lord. Last page. On the left side, there's a serial number on the left side, 8, 25, 26, 27, 28 on the left side. Now, if you also come to 828, just below that, 28 to the date has come in place of number. The date has come. And ink is different, handwriting is different. There is a overwriting like something, my lord, something is there. Then below written is number 829. Then just below that 829A, enclosure. And this looks like, my lord, this is overwriting, kindly see. With bare eyes, it's quite visible, my lord. Now kindly see interesting thing. 9 to 22. Now 9 to 22 in page number, Lordship may come to page number 128. Please. If Deputy Commissioner has given approval on 9th to 22 with memo number 828A, on that day, see the memo number here, 9th top is 9th, my lord. Page 128 top dated is 912. Lordship is 912, then 22, then 22, my lord. Oh, 9, not 90221. This is. If that is so, that this is memo number would have been here, or maybe after 2-3 days they could have entered here. Where is it? No, here.
Please repeat again, did not get it.
My lord. That next page, 829, 829A. This is number, next page, last page, yeah, 129. This would have come serially, my lord. Right, my lord? Now, this is that memo number 829. 29 is by Treasury Officer 829A. If it is on dated 9th February 22, page 50, my lord. 9th February 22. In that case, this would have entered in the previous page, page 128, in the serial register, serial number. See the 9 to 21?
So this 9 to you are getting from where?
120 is page number.
128, yes. 9
Yes.
to,
Kindly see top. 9 to 22.
yes. To
On that day, Deputy Commissioner has approved. Page number 50. Page number 50. Kindly have it, just have a look once. Page 55. This is got hello.
yes.
9 to 22. It should have been in this page, my lord. Assuming, my lord, on that date, the office was very busy. They did not make entry on this date. It could be on 10th, 11th, 12th, 13th, 14th, 15th. Why in the bottom, the left side, in place of number, they put the date and they put this numbers, my lord. Why? And it's overwriting, different ink, different plain space is different. And there is one border, kindly see, my lord. Border line, there's a border, margin, there's a margin. And below that, they have added this, my lord. That is the reason in the writ petition, I enlist malafide in paragraph 28, page 28, my lord. The treasurer officer by name, Ajit Sharma, so something like Sharma, by name I entreat him. He, the advocate appeared, but he has never filed an affidavit. Never, my lord, is there. So the Nasim Manu case comes, my lord. The pleading made in the writ petition was not denied by, it will presume it's true, correct? Nasim Manu. Now, in page number 145,
Just a moment.
my lord.
Yes.
My lord, the one part. Now, he has submitted certain documents. Most of these part of this records. Some 2-3 documents are not part of the records on the writ petition of the extra. I'll bring to you. Now, Lordship will find one thing here in this case. there was some hurry on the part of the respondent authorities because on 20th of February 2022, I was ousted by
Just a new appointment was made. We remember that.
BRS was approved, my lord. On that day itself, selection was made.
And somebody was appointed.
Not only a series were there and in my post was filled up. Subsequently, when I was not paid salary, and my lord, one thing, after the stay was granted, I went to the office, but they are not giving me the main register to sign. Although there was a chair and they gave me an extra register, I used to daily put signature on the extra register. There's no doubt about it. And that Ajit Hajarika, that person, he is there, my lord. I sit there, never allowed me. Now, my lord, all these days, March, they make the appointment. Lordship is seen in sitting in single bench, both the lordships, my lord, in the division bench. When a person retires, how many pension cases are filed for pension? Here in this case, lordship will find 28th, I go out. 29th, somebody appointed. 9th, all the orders passed. BRS, everything done. Then on 14th or 15th, my lord, March, my lord, everything it comes to my account. Then I didn't read, my lord, nowadays bank account is linked with the office, my lord. I remember, my lord, lordship, remember in the old building, last stop there. When there is salary day, my lord, there's a long queue. Nowadays, there is no long queue because salary comes to the salary account, my lord. There's the reason it came here. Subsequently, I wrote to the treasury officer, please take the money back. But nothing was there, my lord. There's the reason here. All of they are in a hurry. Why not do it quickly? And then, my lord, because of that, they filled up the post, money was given in my account, and everything was done, my lord. Now, from all these actions, lordship will find, my lord, what does it presume, my lord? Because in page number 144, 45, under single judges, my lord, can I take the single judge, my lord, order? Page number 144, my lord. Just 144, 45, my lord. 140.
We have seen it.
Lordship seen it, my lord. Okay. Lordship, even single judge was saying 9/2/22, this is communication was nowhere it is found, and the respondent relied on that order, and they said yes, it's perfect. In
Page 144.
yes. In that case, my lord, my application dated, my lord, 21/12/24, signed by Judge Hajarika. I specifically mentioned his name in the repetition, not denied by him, my lord. And there's no entry because there's a gap of 5-6 days, not a single entry, my lord. What does it, my lord, with that, my lord, lordship will presume that, my lord, on the basis of all these facts, my lord, something is wrong somewhere, my lord. So far, this petition is concerned and against her, my lord. There's the reason there is a gap in the entry. And there's interpolation, overwriting, everything is there, my lord. Then, my lord, my lord, so far this interpolation of things, my lord, page number, I just made it so that it become easier for your lordships, my lord. My lord, whatever is submitted now, my lord, I've just written here, my lord. That's the word, my lord. Nothing. So that became easier for lordships, my lord, to find out, my lord, pages. Otherwise, my lord, quite big bunches, my lord. Thank you. Now, my lord, if I take a lordships to the document submitted by learned friend, my lord. My lord, this bunch of papers. Let me answer on those, my lord. Then I think basically. Page number, my lord, is my application, page number 40, my lord. Lordship has seen this, my lord. my lord, that this copy is my lord, given by my learned friend, my lord. Let me just address your lordship on this. Page number 1 is page 41, my application. I have already answered that one, my lord. Next page is page number 47, my lord. The letter addressed to me by the treasury officer. That is, here is page number 2, there is page number 47. Yes, I think so, sir. Lordship is good, sir. Now, page number 2, in readable, it is page 47. Even Lordship may just note down the mark, page marks of release, my lord. Even Lordship feel, my lord. Okay. So this is what I may address, my lord. Nothing is mentioned. Which is the authority? What's the date? What's the number? Nothing is mentioned here. Next, the Deputy Commissioner approval. That 9/2/22, memo number 8/29A. This is what, my lord. That also I have addressed already, my lord. This you will also compare with the page number 47, my lord. That memo number this 6, my lord. And so the treasurer officer copy was not given to anybody. In my appointment order, promotion order, copies are given to these four, all the authorities. Director of Finance is a compulsory, my has to be given. This is where Lordship will find not a single letter sent to this school. They knew it with the plan, my the reason. Anyway, my lord, now so far page number 4, I want to make my submissions here. Page 4 number 4, 5, 4, 5, 6. 4, 5, 6, my lord. My lord, the Honorable Court has pleased to pass the notice and stay on 3/6/22. Thereafter, the affidavit was filed by the Deputy Commissioner on 22/8/22. 2 months. I would submit. And thereafter, my lord, the response 4 filed on 25/3/23. Response 4 by Treasury Officer. In Deputy Commissioner's letter, there is not much, but in Treasury Officer's, my lord, affidavit, it was filed on 25/3/23. Now, stay notice and stay 3/6/22. 4 months, my lord, there and 3 months here. 7 months. After 7 months, Treasury Officer passed this, my lord. This, my lord, filed the affidavit. And in the affidavit, my lord, page 4, 5, 6, 7, 4, 5, 6 has been, my lord, incorporated in the affidavit, my lord. My submissions, my lord. Those documents are not there at all. Had there been these documents chronologically, would have been mentioned in the register, because those letters are outcome of these documents. These documents, subsequently, they have, my lord, constructed these documents, my lord, they made. That's the reason, my lord. It doesn't tell with memo number. Why there's a gap? Had that been on that, immediately all the dates said there, memo numbers are there. That's why, my lord, according to me, my lord, this is constructed subsequently, my lord. And kindly see now, see page number 5, my lord, kindly see. Page 4, 5, 6, my lord. 4, 5, 6. Kindly see in page number 5. There is a written there, approved, and the DC, left side, kindly see. 9/2/22. If the 9/2/22 was signed on this, this document was approved on 9/2/22, it would have found place in that register. It was sent to the treasury officer. You take action accordingly. Where is it? Lordship, it is not there. It is mentioned on 22 in the one page 129 button. Why? Why chronology was not mentioned? Why?
Firstly, there can be a reason for that, because these are office notes. On the basis of office notes, only if a memo is generated, then it will be there.
The memo's number is what? 839A. Then again from the other side also, it catches.
can know, then subsequently it will come in the register. Immediately it may not come.
9, 10, 11, 12, 13, 14, whatever, but the same memo number, how will we tell you, my lord? Same office, same JT 05 2021 829. But our lordship is satisfied. Lordship is satisfied, my lord. I've got my doubt because
Whether we are satisfied or not, that our pen will say.
now because how can it be, my lord? Or 20 subsequently, then order has been made 20 to 829 8 20 20 to 829 is of 20th February. Cannot be. Memo number cannot become like that, my lord. It has to be serial number. Prefix will be there, my lord. Suffix with variant will come later. The system. This is prefix, that is suffix in variant. My lord, somehow I lord, he is convinced, my lord, it's all right. I put a question to it. Yet, beside this, what answer they will give, my lord? What answer will come, my lord? Because this will tell you with page 129, there is a double marking, overwriting, space is not there. When in place of number, the date has been given. In place of date, number has been given. How? Why? This casts doubt in the minds of lordship and definitely, my lord. Why? That's why I said, my lord, I leave to lordship, my lord. It's not that. I leave to lordship. This is a food for thought, I feel. That's the reason. Otherwise, this page 129 answers all my questions. And page 84.
Mr. Nath, when you are in the bench, we try to be good. When you say something, we say yes. She will speak up and then say this, as is yes.
No, but there's some variations. There are some variations. This part, my lord, we must keep it separated from this part. Otherwise, we cannot develop. System will not develop. It has to be separated, my lord. It has to be there. We have to understand this. Otherwise, there will be a problem. But till today, I have got no problem, my lord. I put a lot of years. I've never faced any problem. No, I have never. Why? I accept this system, my lord. That's why. Now, my lord, please come to page number 7 of this sheet. Page number 7, 8, 9. These 7, 8, 9 are not part of the records. It was never produced before, not annexed to the affidavit, or it was nothing was mentioned in the affidavit about these orders, my lord. Not part of the record. That is what, my lord. See the date? 14/3/22. I get everything. Next page also, page number 8 also. I get everything. 7,56,000, I get everything. 17,000 I get. Then page 9 also, 14/3/22. Here also I get entire amount. Not part of the record. So hurriedly it has been done, my lord. Purposely. This is official. And lordship has dealt how many pension cases daily? And from my experience, one thing I found, my lord, because I was in the pension department for 4 years. And Honorable Justice, ever, my lord, whenever the pension case came, I immediately should take with the commissioner, my lord. They gave me free hand, my lord. Honorable Justice, I still remember, Justice Chintamalla Barua, my lord. The moment there was the pension case, without passing or asked me, Mr. Nath, I said, my lord, done, I'll do. Large number of cases, my lord. I took up with the principal secretary. Why this? It's surprising, my lord, was surprised to know one thing. Today, let me tell. One day, one staff didn't come to the office. The subordinate went to his room to find out the particular file I asked for. He came to a chamber and he told me, you know where I found that file? It's locked in the drawer. Pension file. So many, and who comes for pension? Lordship will might have noticed by now. From my experience, I say, official level officer, those are officers, my lord. Lordship will not file a single pension case in the High Court, not a single case. Who comes? Grade 1, grade 2, grade 2 and grade 3. Grade 3, grade 4 mostly come. Then grade 2, they come. All the pension cases. Not a single officer I have ever seen come to the court paying for pension. No. Those lower level, they suffer. Even after my lord, my term was over, or my colleague, my lord, he came to me, he told me, my brother.
This is exemplary, you got without asking. This is exemplary service. You get without asking.
That's what, my lord. Anyway, my lord.
And not a letter of thanks.
My lord, anyway. My lord, this is what my submission is, my lord. And another issue, my lord. In this sheet, my lord, he has given one metric birth certificate. Page number 21. Kindly see, my lord. Page number 21 and page number 22. Certificate.
You know, this argument you are making, I can make it very lucid in a very horrible example, which I can give. You see, if somebody for some reason comes and asks me for 100 rupees, I'll have to go to the ATM, get it, and then give it to the person. So the most dissatisfied person on earth with me is my family. Every time I have to go to the ATM, get money, and then give it to them. And when I was there, then that was not an issue.
No, because there was no system also there. Nowadays, they
No. Then that was not even required because every time we had something in the almirah, so nobody would ask me.
Oh, they used to pick up from there. Yes.
So now there is a difficulty, and in this case, it is the treasury officer who is making the disbursement. He has a lot of money, and
Lot of
therefore
money. Why not?
making it sign and issuing a pension paper and payment to your home will not be difficult. It will be just like
I bow down to Lordship, my lord. On these, my lord. But one thing, so far this BRS is concerned, this is one part, and so far in the sheet, Lordship will find some documents he has brought, like a metric birth certificate, health certificate, my lord. If that issue they've raised now, after I took the BRS, are they sleeping all these years in the office? Why did not defendant proceeding against me, my lord? Now, once I retire, they come forward and say, this document, that document, metric pass is not there. Why not to initiate a defendant proceeding against me under Rule 9? Appeal rules. Now so these arguments, my lord, doesn't suit in this so far the BRS is concerned, my lord. This is different subject, my lord. So I'll not mix up with these two, my lord. May discard that judgment, that part, my lord. That is not the issue, my lord. Issue is whether Rule 56C has been complied with or not, my lord. And on these backgrounds, page 89 especially, my lord. And at last, my lord.
yes.
My lord, basically, what else would public? Now, if there is any query from your lordship, my lord, I can answer, because from my side, I feel, my lord, and I also feel that they will know that in this case, I don't have to again. I'll go to promotional, my lord, and then I'll take a bath. Enough, my lord, from the petition stage, my lord, I got tired in this case, I feel, my lord, really. One case, repeat, whenever it comes, I read. Last night also took so much time, my lord, and then second appeal is there in single bench. That file I read after 12 o'clock, and then I could not finish, my lord. Yes, before single one, I was just on single, item on 9. I said, because I have to answer that one also. So this one, that day I know I don't do API, my lord. I take a bath, my lord, and probably, my lord. I link the loss, my lord.
Ms. Barrow, if you have to, if Mr. Naik has to say something tomorrow morning, give a written note with copy to the instructing counsel for Mr. Nath.
Lordship.
Correct?
Yes, it's a submission to you in this.
We'll reserve it. Good. Yes, people and counsel for the counsel appearing on behalf of the learned Mr. P. Naik, learned additional advocate general for the state is present. It is submitted that he's on legs in another court.
Lordship, he's on the way, Lordship. He's on the way to the court, Lordship. It's an important matter.
Okay.
We'd like to work, Lordship.
She pays for some accommodation as the advocate general is additional advocate general is not present. So as this is a part and matter. The court has proceeded to hear the submissions of Mr. M. Nath, learned senior counsel, assisted by Mr. M. Nath. Huh? A. Bhattacharya, learned, A. Bhattacharya, learned counsel for the respondent. Number one, respondent number one.
Yes, ma'am.
Number one. The learned additional advocate general may submit a brief note of his submissions to the court master by tentative review by 28 by sorry by 27 by 27 by 2026 with a copy to the learned industry instructing counsel for the appellant, respondent number one. First of arguments are concluded, judgment reserved.
Obligement.
May it please your lordship, I beg to mention item number 10 of today's daily list for adjournment. I am appearing on behalf of appellant, I am appearing on behalf of S. Das Gupta for the appellant. Actually, we have submitted an adjournment slip, taking the consent from the other side yesterday, showing the ground that the case record has been lost relating to the file, and it needs to be reconstructed, your lordship. So we need some time. S. Das Gupta for the appellant. Can it be after 4 weeks, your lordship? Highly obliged. May it please your lordship, with the consent of other side, I beg to mention item number 15, lordship. Lordship, matter may be fixed on June. Item number 15. Miss R. Chaudhary.
For the respondent.
Lordship, I beg to mention item number 12. I have also taken consent from the other side advocate. Kindly we fix on the June.
Lordship, with the consent of the other side, I beg to mention item number 5, Lordship. I'm appearing on behalf of Mr. O.P. Bhatti.
Item number 5, 2011. No.
Lordship, Mr. Bhatti is not keeping well, so a short date may
We
kindly.
don't know, no short date. 2011 matters we can't adjourn. Leniency pray when the matter is
Let it
called.
come tomorrow, Lordship.
We'll pass orders wait till the matter is called.
May I please your lordship, in item number 6, I am for the respondents. Lordship, wherein the respondent number 2 has expired 2 weeks ago, Lordship. So his legal rights are required to be substituted, Lordship. So 2 weeks time may be required for filing a petition after getting a death certificate, Lordship.
Right, 2 weeks ago.
2 weeks time may be required.
No, when the respondent to died.
2 weeks ago,
Okay. Your name?
S. Sodol. S. Sodol, Lordship. On behalf
As
of
per the
S.
London
Sodol.
Council appearing for the respondent number 2 submits that the respondent 2 has expired about 2 weeks back. And she prays for and is granted 2 weeks time to take appropriate steps. And to produce the copy of the death certificate. Next para. The London Council for the appellant shall take note of the submissions that the respondent 2 has expired and take appropriate steps. List on, give a date after 2 weeks.
Lordship, I am appearing for 2 respondents, Your Honor, wherein respondent number 2 is expired. I am appearing for 2 respondents, Your Honor. Yes. Only respondent.
What is the serial number of that? In the memo appeal, what is the serial number of that person who has died?
Respondent number 2.
Respondent 2.
Lordship, I am appearing for the appellant in item number 6. In item number 6, I am for the appellant.
You have for the appellant, okay, appellant is represented. You take note of the submissions and do the needful.
Public knowledge.
Mention item 11. Motion on this matter, respondent is being led by opposition counsel.
Hmm?
Respondent is being led by opposition counsel. Is not able to make it physically present today.
2017 matters we are not adjourning. You can appear online.
Also on the last date,
We don't know, in 2017 matters we are not adjourning. These are 8 years old matter. You can address us online.
possibly accommodate for this time, because last time we were ready, the council was physically present for
We are
that.
not accommodating. We'll call and then we'll see.
Will be-
Yes, item 1, no, to be spoken to. This is item number
16.
16.
16.
Item 16 to be spoken to.
Mr. Saiwala, yesterday we made that calculation. It was wrong. The application is within time.
No,
Yes, we have made that calculation.
no, you'll also see.
We have done the calculation. We have reconfirmed it. You see, we'll tell you what has happened. The
14/1/24 died. 14/1/24 died.
just a moment. Yes, 14/1 died. So 90 days would
90
be
days, 13/4.
13/4.
13/4.
Yes,
Yes,
and then that is 90 days.
90 days.
And then for setting aside amendment 60 days. So 60 days time will be from 14/4 to 13/6. And this application was filed on 6/6.
60. So that setting aside amendment which we filed, because after 90 days, the abates,
Yes, it's a base.
abated already, should abated.
No, but then we'll have jurisdiction, still we'll have jurisdiction. It is on rejection of that application of for order 21, sorry, order 43 rule 1K. Applies only on rejection of that application. That application was never there.
They have setting aside amendment application has not
We
been.
delegated them to go for an appeal.
Yes.
Their appeal jurisdiction will not come because that application is not dismissed. Look at the CPC. Order 41 rule K does not, it is on rejection. Appeal will lie.
No, rejection, the convention petition has been rejected. That is the.
But then revision will lie. Then we'll have jurisdiction.
No, well, I'm. Well, with this convention petition may be treated as application for certification of abatement. That is to be my lord, because 60 days has not
We
expired.
are not on that. Yesterday we remanded him for an appeal.
Appeal, yes, appeal will lie.
The appeal will not lie. See, order 41, 43-1K.
Yes.
It is on rejection of that application. Then appeal would lie under 43-1K.
My lord, 43, an order under Rule 9 of Order 22, refusing to set aside a management or dismissal of a suit. Yes,
That was never there.
no,
So the application, that continuation application can be treated here and then we can proceed with that. But then we would have jurisdiction. We can't be relegated to appeal.
yeah, but what I my lord, that Mr. also said that even if the language is not there, it is convention, then it can be treated as an appeal.
We understand that, but who will have jurisdiction to do that? Under 227, we will have that jurisdiction. Or we can send it back to the same court, but not in appeal. Yesterday, we passed an order to relegating him to go for an appeal.
It will be same court.
It will go to the same court, not to this appellate court. Appellate court will have no jurisdiction because their jurisdiction will come
Yes.
only when it is rejected.
Yes.
That's why. So that for that motivation, we have listed it today.
Same court.
Same court, it will go to same court. And they can treat that application as one under order 43-9 and then proceed. After the order, we again rechecked and then found that calculation was wrong.
But amendment has taken.
Yes, amendment has taken.
I was under the impression that application is treated as an application.
So we'll do that, but not in appeal. It has to go to the same court to treat it as an application on the order 40, what do you call order 9 to 9 and then proceed. 22 to 9 and then proceed. That's all. We'll pass the orders today.
Thank you.
For admission, item 1.
Please, Your Lordship.
Yes.
This petition has been filed by the wife lordship to transfer the divorce petition filed before the family Kasa lordship to Sri Bhumi lordship. I am
It
the
is
wife.
hardly any distance. Why you want to get it transferred 40 kilometers only?
Lordship, the thing is that I am on the roof of my parents lordship. I have few source of income and it's difficult to me to travel to Silchar. And there I filed in coding was Sri Bhumi lordship. I filed a maintenance petition lordship. And he appeared that and later him become absent and Honorable Court declared expert lordship to pay maintenance of 6,000 rupees. And regarding that petition, he filed review before the lordship before Sri Bhumi lordship. District and session of Sri Bhumi lordship.
Where is the statement that you are not getting any maintenance?
Lordship, the petition has been disposed after filing my petition before His Honorable Court lordship. Before this, after filing the transfer petition, that criminal petition has been disposed of 120 of share pillars.
Has been disposed of.
Lordship.
With what order?
Expert lordship.
With what order?
That page 27 of the affidavit filed by the respondent lordship. Elector Eman. Order dated 17/6/2025.
Okay, and what do you say?
Lordship, we have already filed our affidavit in opposition, my lord. Our
Yes.
basic contention is that, my lord. So far the transfer is concerned, my lord, the petitioner has failed to show any balance of convenience because the traveling distance is not so far, my lord. Apart from that, my lord, the respondent is working at Arunachal Pradesh, my lord, admittedly. And it has been also mentioned by them in their application also, he has been working at Arunachal, my lord. So it is also inconvenient on our part, my lord, to travel to Sribhumi, my lord. And so far the pendency of other cases is concerned, my lord, only one revision.
No,
petition is
you
presently
refer
pending.
to balance of convenience. When you can come from Arunachal to attend the court at Silchar, what would be so bad to travel to Sribhumi, 40 kilometers? Balance of convenience.
Rest I leave it to your lordship, lordship. We have already made our stand clear, my lord. That is our case, my lord. Rest I leave it to your lordship.
I'm under the roof of my parents, lordship.
Admittedly, one case is pending, my lord, maintenance case. Now revision has been filed by the respondent, my lord. That is pending before the learned court of session judge, my lord, district and session judge. So in Sribhumi, my lord, in Sribhumi.
Mr.
KD Sharma.
K.D. Sharma, and counsel for the petitioner. Also heard Mr. P. Das, learned counsel appearing for the respondent. Next, by filing this application under section 24 of the CPC, the petitioner, who is the estranged wife of the respondent, is seeking transfer of the matrimonial proceedings, being FC within bracket civil number 475 of 2023, from the Court of Learned Principal Judge, Family Court, Kachar, Silchar, to the Court of Learned District Judge, Karimganj. Next, the prayer for transfer has been made on the ground that the petitioner is presently residing with her at her parental home, and it is projected that she has this SYSTS in her stomach and requires surgical intervention. And therefore, it is difficult to appear before the Court of Learned, the Court of Learned Principal Judge, Family Court, Kachar, Silchar. Next, it is also projected that the petitioner, as well as the respondent, is appearing at the Court of Learned Chief Judicial Magistrate, Sribhumi, in proceedings which has been filed under section 125 CRPC, which is registered as Miss 35A of 2023. Next, the learned counsel for the respondent has opposed the application on the ground that the respondent is serving at
He's carrying out his business at
as a business, he is carrying out his business in the state of Arunachal Pradesh, and it will be inconvenient for him to appear at the court of the district judge, Sribhumi, next para, on a consideration of the fact that the distance between the court at Kashar and the Silchar at Kashar and Sribhumi would not be more than 50 kilometers. In that view of the matter, the court is inclined to accept the contention of the petitioner as sufficient cause for transfer of the said matrimonial proceedings of FC within bracket civil at 475 of 2023 from the court of learned principal judge, family court, Kachar, Silchar to the court of learned district judge, Karimganj, Sribhumi, next para. Accordingly, it is provided that the petitioner, on producing a certified copy of the order before the learned principal judge, family court, Kachar, Silchar, the said learned court shall fix a date of appearance of the parties before the court of learned district judge, Karimganj, and transfer the records. And the parties who are represented shall appear before the learned transferee court on the date fixed by the learned principal judge, family court, Kachar, Silchar. Next para. The application stands allowed to the extent as indicated above, so there shall be no orders to cost.
Public.
Item 2. Yes, Mr. Chaudhary.
The counter finding by the execution up this matter. Here, matter the judgment, implement judgment is dated 9/11/25. Passed in TA number 9/21 by the learned civil judge Ajay. I was appeal dismissed upholding the judgment and degree. Passed in 10/4. 3 of 2019 by Munshi civil judge Ajay. Here, man, this case, madam, I have the subsequent question by the case.
You are the defendant.
Yes, sir.
The case is for right title and interest and possession.
Yes, yes. Now, here, the question is this, madam. Only two substance questions will come actually. My humble submission that he said it has been upheld by that he is proved by bringing price by and I could not prove my said it by the main ground by I read the issue number 2 by that the person from whom I purchased money, they died prior to the sale it, and they proved their death certificate that their sale it has been duly executed by them. But that has not been properly discussed by the court below. Why in my case, my lord, that certificate produced were rejected by that. That is my substance question, my lord.
Give us the date of both these sale deeds.
Yes, sir.
You both purchased from the same vendor.
No, my lord. Original vendor is same. I said, my lord, I claim I purchased from the original seller, original owner. And they purchased subsequently from my lord, defendant number 5, my lord, Pramod Chandra Das, my lord. He appeared by the defendant number 5, but he filed written statement. He stated that he did not sell any land to them. Of course, he did not come in the witness box as witness. He was made defendant by that, and that is why his statement was not considered. But he was not placed by that. Yes, ma'am, I am giving the number, my lord. Ma'am, sale deed number, his sale deed number, plaintiff sale deed number 622 of 26/2/82.
Your sale deed.
Plaintiff.
Plaintiff LDD,
Yes, way back, my lord.
what is the date?
Date 26/2/82.
26 to 1982.
And
And
the
your
second,
sale deed dated is 13/9/94.
yes, my lord. That is my lord, sale deed, my lord, but there are two sale deed, my lord. Another one, that was 82, my lord. They purchased 82, my lord.
Purchase it on
The second sale deed, my lord, that is 82, the 5/3/82.
5/3/82.
82.
This 26 to 82 was by whom? Executed by whom?
Executed by my lord, the Pramod Chandra Das, who is defendant number 5, my lord.
26 to 82
82.
is by Pramod Chandra Das.
Yes, by Pramod Chandra Das.
This is plaintiff.
Yes, this place. I claim, my lord, I purchased.
Pramod Chandra Das is defendant number
Yes, defendant number 5, my lord.
defined. Yes.
Defendant number 5. Defendant number 4 is sir.
Now your sale deed of 5/3/82 was by whom?
My sale is, my lord. My sale is 97, my lord.
No, 5/3/82 you referred.
Yes, sir. Yes, 5/3, it is, their sale, two sales. There are two sales.
These are both by
Yes,
the,
yes.
what do you call, the plaintiff.
Yes, yes, yes. 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 And all this connecting sales, but in between, so many sales were there, my lord, of plaintiff and this, Pramod Chandra, this link, the link, all were approved as certified copies only, they approved. Original were not brought on record, my lord. So far as my sales is concerned, my lord, I want, my lord,
Your is 13/9/94.
oh, yes, yes. 94. Exhibit
This is
form.
from,
Yes,
this is from, who is the vendor?
yes, vendor is my lord, Nandeswar Lalu and Punaram Lalu. Original seller, my lord. Original owner, my lord.
Kindly give the name again.
Yeah, Nandeswar Lalu and,
Nandeshwar Dalung.
yes, and Sunaram Lalu. I just get it correct, my lord. Puna Lalu, my Nandeswar Lalu and Puna Lalu, Puna, Puna. The plaintiff said that the Puna Lalu and exhibit Pungo and exhibit Shaw, my lord. At the time of execution, they were not alive, my lord. Died in 94, my lord, prior to the sentence. And we also produced the death certificate, but then those were under objection, my lord. The question is this, my lord, the trial court did not properly it is a serious issue, my lord. Explain the why it has been rejected, or why their one were accepted, my lord. And that is why one of the substantial questions whether 67 has been properly applied or not. my lord. It will also link to perversity also, if at all. It can be checked, Your Honor. in issue number 2, my lord, only one line I will read, my lord. Issue number 2, page 44, my lord. How the trial court has discussed this. Upon perusal of the evidence of either side, it appears that defendant did not prove the document exhibit would go and show as per law of evidence. Now, what as per law of evidence, my lord? Why, what I did not, Your Honor? A mere exhibition of the document in evidence does not amount to prove the contents of the same. Exhibits show and will go. By if that is accepted, my lord, then my said it would have been accepted, my lord. Unfortunate part, I did not claim counterclaim. I did not have any counterclaim. That is, so many cases I have found, my lord. My counterclaim should have been there.
Which page is the first appellate order?
Yeah, my lord, issue number, yes, the order is page. Where is page, my lord? Yes, page 37, my lord, answer E, my lord. There is a trial court, appeals court order, your lordship. Trial court order is page 37. And
And the appellate court is
yes, page 55.
55.
Yes. The issue of that is Promotional Das, who was the vendor actually, that should have been taken a little bit seriously. Though he did not come in the witness box to prove his statement, but after all, he on oath he has submitted written statement, madam, stating that he did not sell the land to the plaintiff, madam. That
No, but he did not come to adduce evidence.
yes, that I understand.
If he did not sell it,
Yes,
that means he would be the owner.
Yes. But again, it was the duty of the plaintiff also to bring the vendor, madam, to prove their safety, to prove their safety. That is the first. He is the first and person, madam.
I don't know, you see, this is, that's why it is taking me some time to understand.
Yes.
You see, what has happened here, the plaintiff comes and says that he has purchased the land.
Yes.
He gives the name of the vendor. That vendor is made defendant number 4.
Yes.
And he said that the defendant number 4, he files a petition that defendant number 4 who sold the land.
No, defendant 4, he said, I did not sell the land.
No, this Nandishwar and this Punar alone. He
Yes.
says that he sold the land, but the original sale deed was with him,
Yes.
and therefore he proves this. From here, we don't find anything that the secondary evidence was allowed. Now, the defendant number 4 comes and gives a statement that he did not sell the land,
Yes.
but he did not come forward.
Yes, he did not come forward.
Now, so far as the title deed is concerned, if somebody claims on the basis of title and demonstrates a sale deed,
Yes.
and you take a plea that it was a forgery,
Yes.
now the burden will be on whom?
Yes, I understand, my lord. They have also taken the ground of forgery on the same issue, my lord.
No, but there is no counterclaim.
Yes, that is the unfortunate part that so many cases
There's
I
no
have found,
counterclaim.
my lord, yes, should have been there, counterclaim. But even then, it is the duty of the plaintiff also to prove his sale deed and to cancel my sale deed. He has to prove, my lord, Section 67, of course, he has done, my lord. But here, my lord,
You took the plea that the vendors, that was a forgery. He did not sell it.
yes, yes,
But that would be a burden on you, not the.
yes. Yes, of course, but the plaintiff filed the suit. He used to prove, even if I
No,
don't,
he,
even if I don't prove, my lord, he used to prove the case.
he proved the, what you call the certified copy of the sale deed. He gives a reason
This-
why original was not there. He
Yes.
gives a certified copy,
Yes,
and that was never disputed.
yes.
In this order, we don't find anything from which, in the cross-examination of the PW1,
Yes, sir.
anything could be, his evidence could have been found to be inconsistent. That we are not getting.
Uh-huh.
That is issue number, that is issue number 3.
Yes, issue number 3, issue number 2 and 3 is important, my lord, in cargo judgment, my lord. Issue number, your lordship, if your lordship take issue number 2, my lord, cargo judgment, my lord, that will,
Whether the sale deed, 13994 is forged, that is your sale deed.
yes, my children. Now, I have also got the document, my lord, but those were under objection not considered by the court below. Now, why not considered? That has not been explained. That is also important, my lord.
Because the fact that the vendor himself comes and says no.
No, they are saying Nandeswar and ye expired, my lord. Prior to that, how they can come, my lord? They are saying they died prior to 94. Those vendor did not turn up for the witness, my lord. These aspects are also there, my lord. Maybe it's a tight case, my lord, but some
But
maybe
then every point you are arguing is a question of fact, not question of law.
no, but question of fact is related to perversity, my lord. If the finding comes to a certain goes to a certain that stage, my lord, that it can alter the finding, my lord, then that it may lead to perversity also, my lord. It can be a ground for perversity, my lord. The perversity substance question can be framed, my lord, for perversity, my lord. I've taken that question also. I've framed, my lord. But these are all interconnected.
But you see this, that won't become a substantial question of law. This, see the first appellate judgment.
Yes, sir. Additional issue, my lord. I think all the grounds, my lord.
See the grounds you have taken at page 16. That is.
Yes, sir. Yes. Yes, that is I have seen, my lord. Yes, sir. Oh, my lord, one more thing I just like to point it out. Initially they filed the suit against two minor person, my lord. There were 4 years or 5 years, my lord. Subsequently, those things are also very important in this case, my lord. Subsequently, they came to know, oh, these are the minor persons, how they can occupy our land. Then they immediately amended in 2000, after 3 years, my lord. That is that itself with the order. And that is why Provision Order 32 Rule 3 was taken in the first appellate court before the first appellate.
Who were the minor persons?
Yes, against initially they filed the suit against two minor persons only, my lord. There is Samsuddin and Almasuddin. They were 4 years and 3 years. After 2 years, my lord. Yes. After 2 years, 2000, they have substituted by a Kutubuddin my lord. It is then the order. Yes. There's the order reflected in the judgment also, my lord. Probably. Because kindly see the original my lord, page 16 my lord, from which I have typed it my lord.
Page 16.
Yes, page 16 of my memo. There is handwritten down below my lord, substituted. And it is reflected somewhere in the order also. There is Muhammad Samsuddin Al-Muslim, both are son of Kutubuddin. Though they were minor. One was born on 4/6/94, my lord, and other was born in 1990, my lord. Only in 2000, my lord, they have amended, my lord. 31/8/2000, my lord, they have amended.
This should help you.
Yes,
Please
of
come
course, this is they are defined.
please come to order 32,
Yes, order 32 is also there.
rule 2.
Yes.
Where a suit is instituted by or on behalf of a minor without an extent. But even in this, even in that page you are referring to, that handwritten copy, so and so, but after that they have amended.
Yes, they have amended.
Include.
Of course, they have. I am admitting they have amended.
Number 3 was included.
Suit is without an extent, plain to take it off. Where plain is on behalf of the minor without the national may apply, and to have the plain taken off the file as the cost to be paid by the solicitor. Notice to appear. The appellate court is actually covered up this thing. The appellate court actually covered up this thing.
There are your certain questions of law.
Yes, by the substance question of law, my lord. Page 4, my lord. One substantive question, my lord, your lordship already answered, my lord. Probably that may not come, my lord. First one is the substantive question of law as to whether the respondent plaintiff had lawfully proved the sale deed so and so, to which the claims the right title of the suit that as required under section 67 of the Evidence Act. Next one, my lord. Appeal the substantive question as to whether learned appellate court, so learned appellate trial court appellate committed serious error of law in declaring the registered sale deed number so and so executed in favor of the appellant, defendant, and the suit and spouse the void of initio. This is also an important point, madam. I may not, my lord, make a counterclaim, my lord. But you have declared my sale deed the void and illegal, my lord. That death certificate also, I have also produced the death certificate. Maybe, and this next one, my lord, third one, my lord. The subsequent question is whether the findings are by the trial court as well as the appeals court suffers from perversity. If your lordship thinks otherwise, madam, then this perversity and this truancy can be clubbed, madam, if at all. Otherwise, I leave it to your lordship, madam.
No, Mr. Chaudhary, you see, you are reading this substantive question of number 1. The second appeal raises substantive question of law as whether they have lawfully proved sale
Yes.
deed,
Yes.
which he claims as required under section 67 of the Act. Now, 67 of the Act, I think that is by proving the original in the signature.
Yes, signature and handwriting and all this. thing.
You say that it is forged.
Yeah, I said, madam. Of course, I did not make any counterclaim.
That's not there, and therefore, you see,
So those will not come.
now this, I'm just asking myself,
Yes.
if A purchases a plot of land, this sale deed was in 82,
82.
and the suit was filed in,
And 92, I think, 98 probably. Yes. So it was filed, madam, 98.
98.
Yes.
So therefore, for
Around 16 years.
16 years, the purchaser will have to keep a track of the vendor,
Yes.
where is there, where is not, and then bring him when this
When
transaction comes.
necessary, yes.
Now, the question is, if they have taken a plea before the trial court, that it was not there,
Yes, sir.
what is the order passed in the application, whether there was an application allowing them to give secondary evidence? And if,
But that is not reflected in the judgment, my lord. That
no,
was,
no, that will never be here. It will be in the order sheet.
yes, it will be in the.
But that has not been got on record. That this was never allowed. The nature of evidence is not before us.
Yes, that is, but, some indication could have been there in the judgments.
No, not required. If you have already allowed secondary evidence,
Yes, already allowed them,
Then
why
why-
disallowed? Yes,
why burden this order?
yes, that will be in the, yes, regular court's orders. Yes.
So at best, if you want to press this, you have to bring it on record to show that this was not done.
Yes, yes, yes,
Otherwise, we are not finding any substantive question of law.
yes, yes.
It's all question of fact.
That is the. Yes,
If you,
yes, yes.
if you
But-
want,
but-
you can just adjourn it to enable you to see if there is anything contradictory in the record.
The record, my lord, the Authorised, so I can see from the. Authorised will be record will be there, from the lower court record, my lord.
Yes, the advocate who was conducting will be able to
Yes,
tell how this secondary evidence
My
was.
lord, my lord,
Because
that
you
can-
see, there is
So
something on-
whether those secondary evidence were
there is-
allowed.
No, because it has to be there, because there is something in this record which shows that this plea was taken. Come to this page 35.
My lord. Page 35.
Now, the plea taken here is that the original sale deed has been in possession of the said vendor Pramod Chandra Das,
Yes.
who left the village and his whereabout is not known to the plaintiff. Correct?
My
That
lord.
is your vendor.
Yes, yes,
Pramod Chandra Das is your vendor.
yes, my lord.
Now, please come to this judgment
My lord.
of the trial court.
My lord, that will be again contradictory, my lord, because he has been made party, my lord.
We understand, but still you took that plea.
Interesting.
Still you took that plea, and now page 45.
My lord. Page 45. Yes. Fourth, my lord.
Third paragraph.
Third, yes, plaintiff side.
Exhibit 2, fourth line. Exhibit 2. First it says Exhibit 1 is the sale deed 622 dated 26 to 82.
My lord.
Perusal of Exhibit 1 shows that the promoter last sold the land measuring so and so from so and so delivered position. Exhibit 2 is registered sale deed dated 26 to 1982. Exhibit 2 shows Pramod sold land raising so-and-so property to plaintiff number 1 and delivered possession.
Yes, yes.
In order to prove Exhibit 1 and Exhibit 2, plaintiff examined by Bhupan Chandra Bora, who is the witness to Exhibit 1 and 2. Plaintiff examined Golok Bora as P2 5, who is the deed writer, and one so-and-so. Therefore, 67 was duly complied with.
Except Pramod, yes, yes. Otherwise,
The vendor is not
vendor,
there.
yes, yes.
He said you said less.
Yes.
So therefore, this was done. So therefore, you don't find a substantial question of law here.
Otherwise, probably same, yes.
Because in this part, Exhibit 1 and 2, it says Exhibit 1 and 2. But come to the next paragraph, 7 to 11 is proved by leading secondary evidence. So the court is conscious of what it is doing. This has to be the original exhibit.
There should have been order. Probably there is an order.
No,
That's
no.
why.
There would not be an order. That's what we are
Yes.
saying. Because the Exhibit 1 and 2 are original.
Also.
And why the-
Only connecting documents are certificate.
And the connecting documents are certified copy. Therefore, the trial court is conscious of the fact that when it is dealing with the original exhibit, it is writing exhibit, and when they are dealing with secondary evidence, it is writing secondary evidence.
That part, if that part is all right, man, then my sense this part may not be all right, man. Because my one is rejected.
You
Who
check
said
up
that there cannot be three cells?
We'll take it up after. We'll take it up after a week. You'll find it out by then.
Madam, I'll try to find out something. Yes, I understand, madam. I've gone through the record. I have to see the evidence. Evidence are very difficult to read, actually. I'll try.
On the prayer made by Mr. H. on counsel for the appellant. List the matter again on.
After 7 days, is it?
Tell us the date. You have a calendar there. Tell us
Yes,
the date.
yes,
We'll
yes.
confirm.
The 2nd June,
Second is a Tuesday. We'll make it third.
is my,
June.
okay. 3rd. 3rd June.
Supplementary item
Alright.
17.
It would be like, that's a tiny mechanism taking it through that.
Hmm?
That too, that's.
For hearing, item 3.
Yes, yes. This is appeal against the concurrent finding of the courts below. The point involved is very short. The originally land was owned by one Sadar Ali.
Just a moment. Yes. Yes.
Originally land was owned by one Sadar Ali.
he had 6 sons. And the land measuring 6 bighas, 3 katha and 1/3 lesa is the property of the Sadar Ali. After his death, the land was mutated in the name of Ali Hussein. One of the sons
Yes.
one of the sons of Sadar Ali. When the other brothers objected, the Ali Hussein parted with the land to some of the brothers. And the 2 sons, namely Mumtaz and Abdul Rahim. Mumtaz and Abdul Rahim, 2 sons. They sold the land to one Usman.
You are the defendants.
Yes. I'm the defendant number. All depend.
1.
All depend.
Okay. Yes.
All dependents means the principal dependent.
Okay. Principal defendants 1 to 10.
1 to 10.
So land was sold to given to 2 persons, Usman Ali and Mumtaz Ali.
Yes.
Usman Ali took possession of the share of the land received by the plaintiff's brothers. But according to the plaint, there was also a partition earlier.
Yes. There's a partition, but there were some disputes among the brothers, among the sons of Sadar Ali. Then, my lord, the Ali Hussein gifted some land to the other brothers and relinquished the Schedule B land in favor of appellates. In favor of Nasir Ali and Nawab Ali by deed number 1143 of 1970.
Which the plaintiff disputed.
Yes.
This is what is plaintiff is disputing.
Yes.
Yes.
My lord, initially the trial court dismissed the suit. Then there was an appeal before the appellate court. and appellate court remanded the matter to the trial court to examine the Ali Hussein, and his thumb impression is to be examined by the FSM. After remand, the Ali Hussein was examined, but before taking the thumb impression and everything, Ali Hussein died. Therefore, that part was incomplete.
Expunged.
Our submission is this: though the Ali Hussein died, his thumb impression was there in the relinquishment deed, as well as in the evidence. Therefore, the court has to send the relinquishment deed and he put the signature in the evidence. If these two are tallied, then I have a case. Your Lordship may turn to page 12.
Just a moment. This Abdul Majid was examined after the remand.
Yes, yes. Ali Hussein,
Ali Hussein.
yes.
Deed of relinquishment is by
By Ali Hussein,
Ali
in
Hussein
favor,
on which date?
date 28/1/1970.
28/1,
1970.
1970.
Yes. And deed number is 1143.
1143, yes. And your sale deed is exhibit number?
Our I mean, we are relying on the relinquishment. We are occupying we are the Nawab and Nasir. We are we are claiming the land under the deed of relinquishment.
Under
Deed of relinquishment.
deed of relinquishment.
Yes. 1143.
There is a deed here in the record, which is exhibit 3. What is that? This exhibit 3?
Exhibit 3 is the power of attorney of the plaintiff in favor of Chand Mia.
Something appears to be wrong. We will send you the records. We will show it to you. This power of attorney, according to you, exhibit 3 is by whom?
Power of attorney of the plaintiff.
Name. Can you give me the name?
Name was not real.
Tanmia.
Yes. Tanmia is the son of Ali Hussain.
Something is wrong. The exhibit 3 is signed by Ali Hussain.
Exhibit 3 is copy murder.
Exhibit 3 is signed by Ali Hussain, and though I am not an expert, but this This file, huh? This three. Sorry, we have, Mr. Sharma, we have flagged three documents. This exhibit 3 is there. First flag is exhibit 3,
Barabar Samia,
correct? Now this is by Ali Hussain. He has signed it. Come to the back page. Just mark the thumb impression in the middle.
yes,
Correct?
yes,
It's a big thumb impression.
yes,
And you will find the contours of the thumb impression is moving towards the right, the middle part, the bend.
yes,
Correct?
yes.
Now see the next one. No, this second flag. Same.
yes. We can,
And he can again sign.
Barabar,
He can sign. And thumb impression is given the back page.
yes, yes. He signed, Ali said, and he put his thumb impression.
Thumb impression.
Ali said.
But when these documents are exhibited, there is nothing on record to show that any objection as to the admissibility was taken. Because this witness was there. He was not accosted with this thumb impression and asked questions. Now please come to that third flag. Yes, this is thumb impression. We can't find out from this. It's not very clearly taken.
Yes,
Next page also is same. I could not track it. Contours are not very easily available. But the document, this examination by commissioner does not say that any question was asked to him on that.
first one, Balaji, it is power of attorney.
But the thumb impression matches. That's why I showed you
Yes.
this. It is signed by
This
Ali
one
Hussain.
is the exhibit. Yes. So far the other is,
First and second is same. Third, I can't say.
second, second, second.
This is the first is same, almost similar.
Yes. Big country. Big country.
Whether this matches with the other one, third one, we can't say. Not very clear. Notwithstanding that, this question, if it's not there, it may not be a substantial question of law to be answered. And that will be a finding of fact. Your submission is that the signature was there and should have been sent for forensic examination.
Yes.
That would amount to if that is allowed, that it could amount the evidence to be brought at the second appellate stage. If you have foundational facts here, the
Why
question
not
that,
we actually, it should go to the expert opinion because we are not the expert.
no, we are not saying that we are experts. That's why when I gave you that record, we said that I'm not an expert. But the fact is that if this question, the foundational facts are not mentioned in the trial court, raising the question, in a second appellate court, can that be answered?
It is the evidence of alia and commission.
Yes, it's in the third fact which we gave you. It is in the third fact which we gave you.
Right. Betul dia pada hak kau. Pada hak kau terkait itu measure sahih hai.
Okay. Where did you read that?
Page number 8. Page number 8. Line 1, 2, 3, 4, 5 from the bottom. Betul dia pada hak kau terkait itu measure sahih hai.
Pass it on your document.
Plain from the bottom.
Yes. Okay, we'll continue at 2.
The plaintiff, the plaintiff alleges fraud in para 6 of the plaint order frequently see. Para 6 of the plaint. But the plaintiff never executed the deed of relinquishment of title in favor of the Novavali and Nasirali. The deed number 1143 of 1970 was not executed by the plaintiff, nor does he know anything about that. The said deed was totally false one. The defendant cannot acquire any title of the land on the basis of the such false and fraudulent deed. This the plaintiff alleges fraud against the defendant that this is a manufactured document. When they alleges the fraud against the defendant, then it is the burden on them to prove that I have committed fraud in executing these two deeds. And one of the two documents, as your lordship pointed out, there is a power of attorney and these two, it is very clear, these two thumb impressions are safe, except the evidence, recording of evidence, because at that time he was at about 100 years. And moreover, the plaintiff did not adduce any evidence in the trial court. No evidence was recorded. His evidence was recorded after remand by the appellate court. Well, I am reading a one paragraph of evidence of DW1. He is Azhar Ali, DW1. DW1 is the son of Nasser Ali, in favor of whom the data language control was implemented. He Azhar Ali. In paragraph number 5 of his evidence in C2 lexically C. Right. At page 3 of the evidence of the বাদীয়ে মিছা গোচৰ কৰি বিবাদীজনক হাৰাশাস্তি কৰিছে। বাদীয়ে গোচৰ দায়েৰ কৰি গোচৰত সাক্ষী দিয়া নাই আৰু মূল বিবাদী পক্ষই বাদীয়ে গোচৰত হাজিৰ হৈ সাক্ষী নিদিয়াত বা ইচ্ছাকৃতভাৱে হাজিৰ হৈ তেওঁ সম্পাদন কৰি দিয়া সত্যত্যাগ ৰেজিষ্টাৰ দলিল নম্বৰ 114370 খন বাদীৰ নিজ চহী হয় তাক প্ৰমাণ কৰিবৰ বাবে মূল বিবাদীজনক সুযোগ দিয়া নাই। বাদীয়ে ৰেজিষ্টাৰ দলিল ইমানৰ চহী কৰি সত্যত্যাগ কৰি দিছে। ইতিমধ্যে দলিলৰ অন্যান্য সাক্ষীৰ মৃত্যু হৈছে। বাদীৰ চহীটো হেণ্ডৰাইটিং এক্সপাৰ্টৰ দ্বাৰা পৰীক্ষা কৰা উচিত আছিল, কিন্তু বাদীয়ে গোচৰত হাজিৰ হৈ সাক্ষী নিদিয়াত উক্ত পৰীক্ষা কৰিব পৰা হোৱা নাই। বাদীয়ে ইচ্ছাকৃতভাৱে গোচৰ দায়েৰ কৰি আদালতত হাজিৰ নহৈ গোচৰ দীৰ্ঘস্থায়ী কৰি বিবাদীজনক আৰ্থিক দিশত অপূৰণীয় ক্ষতিসাধন কৰিছে। Therefore, can presume that it is a false case. The appellate court, while remanding the case, it is reflected in page 12 of the appellate court judgment. Page 12 of the appellate court judgment. It may be mentioned here that the learned appellate court, while remanding the case, giving direction to the trial court to examine Ali Hussain to bring the version on record in respect of exhibit C, the deed number so and so, and gave a direction to examine the thumb impression of the Ali Hussain by FSL. It appears from the record that in compliance with the order of the learned appellate court, Ali Hussain was examined and commissioned. Page 12 of the our memo. it may be mentioned here that, sir, paragraph number 3, madam.
Yes.
It may be mentioned here that the learned appellate court, while resolving the case, give direction to the trial court to examine the allusion to bring the version on record in respect of exhibit K, the deed number so and so, and gave direction to examine the thumb impression of allusion by FSL. It appears that the record in compliance with the order of the appellate court, allusion was examined and commissioned. As he was bedridden at an relevant time, the report was submitted by the commission. The defendant has cited praise for examination of third impression of allusion, but by this time allusion had died. Well, if he died, these two documents are there. One is power of attorney and one is deed of relinquishment. These two documents can send to the expert whether they are the same person or not, whether any fraud is committed or not.
And that aspect of actual evidence be gone into in the second apex stage. The reason is that whatever order was passed on the prayer, maybe it was sending it for what you call sending it for examination. The appeal that application for the evidence, additional evidence, we did not find it.
Additional evidence is there. We have not filed any additional evidence.
It is not there.
We only filed one application to send the two thumb impression to the handwritings like FSL. The burden is on the plaintiff side to prove that the thumb impression is false and fraudulently obtained. And it is not the thumb impression of allusion. And to that aspect, your lordship can see one judgment passed by the Honorable Supreme Court, 2006, paragraph 19. Is it? Both. Both.
Yes, a oral submission that will file a formal petition.
Yes.
But the formal petition never came.
But in the judgment, it is I think everybody but in the judgment, but the defendant has also called examination of third impression of alia. But by this time, alia died.
Then next order, next page is an order.
See, both parties were present. The defendant said already said that they want to settlement the third impression of his right 16 days ago. They submitted by the previous. Already played the commission with third impression, alia. But
Right, so and so already paid. But that paid is not there.
But the appellate court order is there. There is not necessary to file a separate application. But the
This witness was examined in the trial court. The application for sending for forensic examination must come before the trial court only.
yes, but that forensic sent to the papers to the forensic as per direction of the appellate court. Therefore, there is no necessity to file separate application.
You have not told me that. Where is the first appellate order?
First appellate court order is huh? Okay, 61 number three. Okay. I could repeat the number. Vale, order thing.
is there, page 12, paragraph 18.
The earlier appeal number is title appeal number 6 of 2005.
It is there at page 12 of the memo appeal, paragraph 18.
Okay.
Nothing accepted here.
Yes, yes.
These are examined from difference from record and and also give direction to examine the thumb impression of Hari saved by FSF.
That would have been.
Yes.
Well, so far, I gave one judgment, my lord, regarding forgery. Paragraph 19 of Lordship NDC. There is another aspect of the matter which should be borne in mind, a distinction between the burden of proof and onus of proof. The right to begin follows from onus only. It assumes that the importance of the earlier days of the case. The question of onus of proof is greater for where the question which a party is to begin. Burden of proof is used in three ways to indicate the duty of bringing forward the evidence in support of the provisions of bringing all the time, to make and establish that a proposition is as against all the counter evidence. Three, the indiscriminate use of in which it means to be either or both matters. The elementary rule of section 101 is inflexible. In terms of section 102, the initial onus is always in the plaintiff, and if the is in the charge of the onus and make out a case in which entitles him to a relief, the onus is to the defendant to prove those circumstances, if any, which should definitely disentitle the plaintiff for the same. Therefore, my lord, in this case, the onus is on the plaintiff that this document is a fraudulent because on execution of the deed of relinquishment, now it is 56 years has been passed, and we are in opposition to that.
Making these submissions, but if you can please come to the memo of this case. And that those, what you are now urging, not brought by the
No, madam, I also understand this point. When I am preparing the case, I also found what your lordship has found. Therefore, I have make a additional substantial question of law. Your lordship can.
but in technicalities, you again suffer. Section 100, subsection 3 requires that it should form a part of the memo.
My lord, while it is admitted, we are granted time to, we can raise another substantial question of the at the time of argument for the same. So, this was admitted on 27/5/2011.
Yes.
The appellant may raise any other substantial question of law at the time of hearing.
This is a senior counsel. This is the brother will probably happen. Next. The senior counsel, sorry, appellate has deferred the order that is 27/5/2007. Wherein this book by particularly a appeal from substantial questions of law granted liberty to the appellants to raise any other question of law than hearing. In the said context, is the learned statement to the appellant has submitted formulate an additional substantial question of law as to whether on a plea of fraud as stated by the plaintiff in exhibition and registration of exhibit for the learned transport in the learned first captured book at 13 law shifting the onus of proof to the defendants to prove execution of exhibit for submitted that they said they said that it is certainly personal law arises out of the fact that the against the original in the judgment in the initial judgment and decree passed by the unit transport and appeal was preferred and the first appellate court had remanded this matter back to the unit transport to examine the alleged sale of plaintiff to version of record with respect of exhibit for is deal number 1148/1970 and also issue direction to examine the sum impression alleged sale by FSF. By referring to next one, by referring to paragraph 18 of the judgment and decree dated 21/1/2010 asked by the learned civil judge of Oregon in CA 1 of 2009 had submitted that while Having Singh the plaintiff was examined on commission his the report of the commission was placed and when the event site paid for examination of the coming question of Having Singh after by the time Having Singh died.
Before I discuss that yours part of that the other first aspect one. Purpose the basic but name exhibit part of the problem. Bonus was on the basic. But moreover, I might expect that the some impression of the basic was available in the exhibit for exhibit 3 and and these evidence and these evidence.
Correct.
Some question where which documents exhibit 3 and exhibit 3 exhibit call and
Yes, evidence on cross
Exhibit 3, exhibit core, and is evidence. Proceedings.
so those two documents.
Yes. These are the two documents mainly. One is power of attorney and one is deed of relinquishment.
Deed of exhibit call. Power of attorney within exhibit 3. 3. As well as in the examination of the plaintiff has PW5. It was done by the commissioner on 17/12/2006. In fact, to accept these occasions made by the for the applicant. And accordingly. Under the provisions of subsection 4 of section 100 of the CPC, so it's satisfied that additional certification of law is involved in this case. According to is formulated as a as the respondents are unrepresented of the names of their advocates are depicted in the complaint. And considering that the matter has been listed at the hearing forum of the complaint. This is like question of public claim. The matter stands ground as to enable the respondents to make their submissions on such issue as quickly. Next. This again on. Give it 2 weeks. Take this back. Directly you can. It's good that you thought of it, otherwise it could have been dismissed from the exam.
Hello.
Item 14.
Timing, madam. So, on leg, madam.
Item 17.
Yes.
So, my lord, I have started, my lord. Actually, what happened, a decree was passed. We are co-partner, my lord, we were not made party there. So, case was decided and the decree was passed. And at the time of execution, my lord, we came to know about the decree. And ultimately, my lord, we have filed an application under Order 21, Rule 99. And that application, initially it was rejected. Thereafter, we filed a title appeal, my lord, and title appeal, the matter was remanded back. And thereafter, that petition was registered as J case number 29 of 19. And that J case 29 of 19 was also rejected. And thereafter, we filed a title appeal. That title appeal was also rejected. And now I am before your lordship.
Yeah, over, so we should come. Over, please. Yeah, over. Yeah, over. My lord.
So, my lord, your lordship, 13/12/2024, that midday case was dismissed. So, my lord, I'm giving this order to your lordship, my lord. Unfortunately, I could not annex to this memorandum of faith. So, my lord, in that midday case, they did not, the decree holder, opposite party did not prefer any, did not examine any witness. However, they filed objection against our petition. Now, your lordship, in the midday case, the petitioner, that is the appellant before your lordship, examined 4 witnesses, 4 PWs. Your lordship would be pleased to look into that third page of the judgment, my lord, I have given. 1, 2, 3, 4 paragraph, my lord. The petitioners have examined.
Yes.
Petitioners have examined 4 witnesses who were cross-examined by the OP plaintiff side. PW1 Ashok Ali deposed in his evidence.
You are the petitioner.
My lord,
Petitioner means you are the petitioner.
I am the petitioner. Petitioners, my lord, that is myself and my brother. The petitioners have examined 4 witnesses who were cross-examined by OP plaintiff side. PW1 Ashok Ali deposed in his evidence in chief that both the parties are known to him. He used to reside adjacent to the shoot land for last 10-12 years. He also deposed that originally the shoot land belonged to the ancestors of the petitioners and thereafter the petitioners inherited the same. The petitioners are in possession of the land and the decree holder never possessed the land and also illegally mutated his name thereafter, converted one portion of the land to periodic quota without having right, title and interest and possession. Here, my lord, I want to point out one thing. In the plaint, my lord, in the plaint also, the plaintiff did not say that he was in possession. His case is this, that the shoot land is his land. It is converted into periodic quota in his name and he given it to defendants of that shoot for cultivation. And thereafter they refused to vacate the land. That was his case. And another case is this, my lord. He said that land converted into my name, but if your lordship gone through the plaint as a whole, there is no source of his title. He purchased or gift or inherited. Because, my lord, property is to obtain either by purchase or by inheritance or by gift. So that is not available and he did not claim also. Just he started the fact of the case that the land is converted into my name. This is my Medipatta land. So, my lord, the petitioners and thereafter petitioners inherit the name and also illegally mutated and converted one portion of the land to the patta without having any right, title and possession. In his cross-examination, PW1 stated that he was born in Kuri under Mayang PS and used to stay there prior to 50 years and thereafter started residing at Milanpur in his own house 25 years and after that started residing at Hekenamara. he never stayed in Mori Muslim Gau, he does not know the dag and patta number and quantity of the sued land. He further stated that the decree holder is a resident of Hekenamara who is residing over government's land. He was not in possession of the land. In cross also, that further stated that the decree holder is a resident of Hekenamara who is residing over government's land. Not that he is in possession of the land. PW2, similar, shall I continue, man? Allah. PW2 Muhammad Hassan Ali deposed to the same facts in his evidence since he as deposed by PW1. In his cross-examination, he stated that in the year 2013, a suit was filed against the father, which was decided against his father. So, his father was defendant in the case, but father did not contest the case. At the time of execution, his father filed a petition on 15 to 18 that he purchased and residing over the land, decretal land for last 35 years. His father was born in Moirabari. PW3, Azmol Ali deposed in his evidence in chief that original owner of the shoot patta never transferred the shoot land to anyone. It is further submitted that the decree holder Wazuddin, in collusion with revenue staff, mutated his name in the annual patta number 33 and converted 3 kata 17 lessers of land out of 2 biga 1 kata 3 lesser to periodic patta by creating new dag numbers and sections. In his cross-examination, PW3 stated that dag and patta number of the decretal land is 258 and 33 respectively. He does not know the dags of annual patta. So, my lord, here your lordship would be pleased to see the land was not cash land. The land was not cash land that somebody will give premium. And after premium, my lord, land will be converted by the government in the name of somebody. But land was originally annual patta land. So if it is original patta land, my lord, that there is existing title of somebody. So annual patta cannot be converted into the name of somebody by paying premium. So, my lord, when he was not in possession of the land, when there is no source of title, how the decree can be obtained? And that too, my lord, our name is in the record. If he is properly converted the land, then we should be made party. He did not. So, my lord, we take the plea that actually decree is not a legal decree, it is a fraudulent decree. Even the land he could not inherit it. He cannot claim any right on the land.
Come to page 13 of your memo of it.
14, my lord.
13.
13.
Para 23,
23.
last part. In order to prove ownership, they did not produce any documentary evidence.
Petitioners, appellants claim that they are owners and possession of the land. So, my lord, that I admit, my lord. My lord, the document, your lordship, I have annexed with the memo of will now. But actually, my lord, it was not produced before the court below. But my humble submission before your lordship, at least I have given oral evidences, 4 oral evidences.
That would be excluded under section 90.
Okay. Oral evidences. Now, my lord, your lordship will consider that is all right, my lord. There is some not proper conducting of the case. That document is to be produced before the court. But my lord, when the plaintiff before your lordship, plaintiff did not claim anything. He just said that land is converted into my name. How it is converted? That is to be looked into, my lord. The courts below, my lord, had gone wrong. My lord, a source of title is to be necessary enough to get something. how the court passed the decree, my lord. And thing is this, my lord, if we were party, then another thing. Parties were made, those who do not have any right over the land. They did not contest the case. How that decree will take our national.
You see, for that you have to bring some foundational facts.
My lord.
Entering the Jawabandi,
My lord.
there is a decision of this court which says that it has some value. 41 of the land and revenue regulation,
My lord. Jawabandi has got some value.
some value.
My lord.
Now, if there is an entry, and if you say that this entry is fraudulent,
My lord.
then the burden of proving it's a fraud
My
is on the person who is alleging.
my lord. My lord, that is the thing, my lord. All right, my lord, we did not produce any document, and your lordship at the late stage, that is, we are confronted with this, that document has not brought in. He entered his name, my lord, without any basis. So when your lordship pointed out, yes, in the Jamabandi, if somebody's name is there, it will get some weightage, no doubt. But it is also law that mere entering into the Jamabandi, name into the Jamabandi, somebody will not be entitled to the title, because he must show, what I on, my lord, he must show that he has a source. What is his source, my lord? Supposing, my lord,
So your argument is perfectly good,
my lord,
but the problem is that if these foundational facts are not there before the
that is there, my lord. But
first separate court.
to that extent, my lord, I humbly submit before your lordship. That is the mistake. That is a legal question, my lord. I engaged an advocate. He conducted the case. And the advocate, what he did, my name is there. My lord, your lordship will see this document. My father's name is there in the document. That document is not produced before the court below, my lord.
I'll tell you, sir.
My lord. My lord. That is the problem, my lord, that I know something of law. But problem is this, my lord, all the civil cases, my lord. What with limited knowledge, my lord, I get it. I am not so expert in civil law. But always there is conducting mistake. And conducting mistake and the public suffers. Now, my lord, my humble submission, there is loopholes on our part, my lord. But whether your lordship will examine that person, that how you get this title, my lord. Substantial question of law, my lord. My substantial question of law is this. On the entire facts and circumstances of the case, my lord, whether any source has been shown by the respondent that he has a title. My lord. No source, my lord, that is why, my lord, whether mere entry into the Jamabandi, he will be entitlement to the land. Let him answer, my lord. Mere entry into the Jamabandi. That That is a legal question I posed before your lordship. But at least, my lord, I have given some oral evidences. 4 oral evidences, my lord. And by cross-examining us, my lord, that is not diluted. That no, you are falsely stated. The petitioner did not have a pattern and property there. That is not diluted, my lord. My question is this, my lord. Where entering into the Jamabundi, he will get the decree. And now your lordship will be pleased to see. By executing the decree, if I no. But that is there. That is there. That is there, my lord. No, my lord. To that, my lord, I want to humbly answer before your lordship that is revenue part, my lord. Revenue part. But thing your lordship will consider under the facts and circumstances that if I am thrown away from the land and thereafter fight with this revenue level, my lord, the revenue line regarding correction of mutation, etc., etc. Because, my lord, that was a stage I should challenge, but I came to know after obtaining the decree, my lord. So now, my lord, your lordship would be pleased to see whether the decree is legally obtained or not. Only question, my lord, how he come to the land. My lord, definitely. My lord. Mitigation. But order that is 13/12/24. My lord. 13/12/24. My lord, that is not annexed. I have forwarded to your lordship. Yes. Jinnur, my lord. Jinnur Ali alias Jinnur Ali. My lord. Page 10. Jinnur Ali, my lord, PW4 Jinnur Ali. Hi, my lord. PW4. PW4 Jinnur Ali. PW4 Jinnur Ali deposed that the original owner of Shootland are Muhammad Latif, son of Karan. My lord, PW1. PW, my lord. Ashok Ali. Ashok Ali is not petitioner. Not Jinnur Ali and was that FG like this one. The son of original Patada. My lord. Hmm. PW2. Hussain Ali. Hussain Ali not petitioner. Hussain Ali deposed the same facts in his evidence in chief as deposed PW1. My lord. No, my lord, his father, Akbar Ali. His father, Akbar Ali, was a party in the shoot. But he did not contest. My lord. Suit was filed in 2013. My lord. PW3. Not petitioner. Azmal Ali. Never transferred the shoot land to anyone. It is further submitted that decree holder Wazuddin in collusion with revenue staff mutated his name. My lord. My lord. My lord. No, my lord, regarding so, my lord, what your lordship pointed out to me, my lord, regarding partner number and tag number, my lord, it is difficult to remember this partner number and tag number, my lord. My lord, if it is well taught by the advocate concerned, my lord, that this is the partner number, this is the tag number. Otherwise, my lord, this land belong to somebody. I know, co-blazer know. Even, my lord, the patadar himself forget the name. It is to be taught to him, my lord. Not it is not a thing that patta number, dag number, it is a matter that it will be memorized. And thereby, my lord, this evidence will be washed away by the court below, my lord. That is not proper. So my understanding. My lord, my only question is this, my lord. Yes, we failed, my lord. We failed to produce document. But, my lord, a decree passed without knowing into the source of obtaining the entry into the Jamabandi. How the courts below, my lord, given the decree? That is my question, my lord. If your lordship please to examine the same. Let them answer. How you enter into Jamabandi? Where from? Lacuna is there, my lord, on our part. Because we are fighting after decree. We are not made party. My lord, that is there, my lord. But I will pray before your lordship, if some vital document, my lord, is left out, my lord, then option is under 41, Rule 27, my lord. Otherwise, no option, my lord, no way out, my lord. Well, otherwise, what will happen, my lord? That document has been kept out of record for two litigation in Midge case as well as before the title appeal, my lord. The advocate did not know. My lord, this is not fault on the part of the petitioner, my lord, this illiterate petitioner. My lord. My lord. My lord. My lord. My lord. Yes, my lord. A person is said to have notice of a fact when he actually knows that fact, or when, but for willful abstention from an inquiry or search which he ought to have made, or gross negligence would have known it. So, my lord,
entry. And therefore, it is a requirement to have the search made as to how the entry came. A Jamamadi will have that entry, reference to it. Now, in your case, what has happened, there was a entry made and then thereafter there was a patta partition and the new dag and patta was created. Now, if this new dag and patta number is created, your landholding comes down. And in this suit, when you know that, you did not, that part is not contested. And therefore, you see here it says willful abstinence.
my lord, willful absence, my lord, here your lordship, subject to correction by your lordship, the case goes like this. That plaintiff was never in possession. Land was not in possession. Notice will come when he visit the land, when he is in possession of the land. He is not in possession. He is in the record only. And ultimately he obtained the decree. and going to execute the same. Then I came to know, my lord. It is not that, your lordship rightly pointed out that notice, if that particular person was in possession of the land, or that particular person, case of the particular person that he has got house there. No, that person claim in the plaint that I have given the land to somebody else. He was cultivating the land. So they were made party. And he was never visited the land. That I will understand that why he is coming here, madam. Your lordship. So, my lord, your lordship pointed out rightly that I am to go for revenue record correction. But here what happened, my lord? Execution after execution, my lord, my house will be destroyed. Thereafter, revenue fighting, my lord. He was not in possession. That is not his case. He said that land record in my name, I given the land to somebody else. He never cultivated the land, my lord. That is the claim. How he can claim the land? Entire plain is like this. Somebody came, I given. He never said that I was ever in possession of the land. Never.
Yes, it's there.
Yeah.
In fact, in the trial court order, it is reflected.
Yeah.
Where is the copy of the plain?
Plaint, my lord, plaint I am giving you. Plaint, your lordship. It started from page 21.
Because the judgment of the trial court starts that he is a possessor of the land.
No. Suit for declaration of plaintiff's right, title and interest and recovery of first possession. First line, my lord. A plot of land measuring 3 kathas, 17 lessa, covered by dag number 483 new, 258 old, PP number 192 at Hacken
Yes, in paragraph 3, it says that he has been possessing the Schedule A land.
in the state district Mozambique is in the subject matter of the suit. Detailed description of the suit land is given in Schedule A of the plan.
No, come to paragraph 3. He says
Paragraph
that he is in
3.
possession.
My lord.
He says that he is in possession.
My lord, our case he is not in possession.
How do you prove it?
My lord, he claimed that he is in possession. My lord, what happened? The parties were made party. He adduced evidence, my lord. Nobody came to cross-examine them. How the case was won, my lord. Somebody was made party. Kopatadar not made party. They did not contest the case. He got the decree. Your lordship will see the para 2. That as per Jamabandi copy, it starts from Jamabandi. As per Jamabandi copy, the shoot patta is issued for the year 1974-75. It
Because what is
appears
the
that
annual patta land and same has been converted into periodic patta, right, conversion case number so and so. And it appears that patta number so and so and the conversion.
Similar,
patta
it
number
starts
so-
from 74-75.
It's in possession, owner in possession of
My lord.
patta number 192.
And now question is this, my lord. He is in possession. Supposing, my lord, for time being that he is in possession. Now my humble submission before your lordship, where from he get the land?
That is why
Where
you
entry?
show us.
Where entry?
That is for you to show us that those
Hello.
things have not been, not
Hello.
been proved.
He is not in, not the owner of the land from anybody.
Will not be, but see, these are converted. On conversion, what order was passed, we don't know. This
Oh.
order of 2005.
No, that is behind my back, my lord. That is behind my back. If somebody, my lord, enter his name in my paternal property, my lord, without my knowledge, he will get degree and disposes me. My lord, his basis of claim is only this only, nothing else. My lord. But my question is this, how in the name enter into the Zamabundi, my lord? And a stranger will enter into the Zamabundi and will patta land by giving premium.
In defense, in your application, did the plaintiff come to dock? No.
No.
In your objection filed,
My objection filed by the defendants, my lord. They did
no,
not
no,
come.
you filed objection, order 21.
No, they filed objection, my lord, yes.
In that case, did he come for giving evidence? No.
No, madam, they did not read any evidence. He just filed objection or cross-examine the witness. He did not adduce any evidence. That is also, my lord, your lordship will consider that, that to some extent evasive. If you got the decree, you have to substantiate the decree. Decree has been challenged by filing a petition, a legal petition. He did not prefer to file any, give any evidence. Did not. Then the petitioner, before your lordship would get the chance to ask how you get the land, how you get the decree. He did not adduce any evidence. Hello? It is understandable, my lord. If it is the land is a caste land, he himself said it was the annual patta land. In annual patta land, my lord, for his entry, there must be some source, either purchase or by something.
Page 63, what is the name?
63, my lord.
What is the name of this?
1 minute, my lord, I'm giving. Wazuddin, my lord. That is the plaintiff.
This is Wazuddin.
Wazuddin, my lord, this is the plaintiff.
Yes. Then you read the remarks. Remark is Morigaon Jilar Upayukta Mahoday ইমান ম্যাদি বছৰৰ ওপৰত দিয়া ইমান তাৰিখৰ হুকুম মতে 33 নম্বৰ একচনীয়া পাতা 258 দাগৰ অংশ 3 কথা লেচা মাটি 23 নম্বৰ চালান যোগে ইমান টকা আদায় প্ৰিমিয়াম আদায় দিয়াত ইমান তাৰিখৰ নম্বৰ
92 মেডিত
ম্যাদি করা হয় so therefore this premium was paid and this man got the
my humble submission that I am pointed out to your lordship. This is possible in case of caste land, but he himself said that in 1974 75 In annual patta, my lord, how premium can be given?
We don't know.
My lord.
Exonia Patta means it's a government land.
No, Actionia Patta is not government land, because, my lord, Actionia Patta is a land till it is not renewed. If it is not renewed, then it will be government land. Annual Patta, it is continuing and renewed. It is not government. My lord, my humble submission before your lordship, annual Patta land, my lord, annual Patta land under Assam Land Revenue Regulation and wasteland, my lord. There is a difference between wasteland, that is clearly khas land. It is not reserved for any purpose, it is a government land, wasteland or khas land. But annual Patta land is not wasteland, my lord. So, my lord, by giving premium, my lord, by giving premium, my lord, I can, if I am in possession, then by giving premium, Deputy Commissioner has got power to record my name, getting premium. But your lordship would be pleased to see, it is the part of our land. And it is said that some mutation case was started. Now your lordship will consider whether that in mutation case co-partner were issued notice. How that is bifurcated, my lord. That is the thing I pointed out before your lordship, that it is a complete fraud, fraudulent decree. So, my lord, let him come before your lordship and explain.
No, second appeal is not admitted.
My lord,
It's not a case to admit the second appeal.
my lord. No, my lord, in that case, may I pray before your lordship? What questions I have placed before your lordship? Let the notice go. Let the notice go and let them come and hear before admitting.
You have to admit the appeal and then.
My lord.
This is not the proper way to deal with the second appeal.
My lord.
I have my reservations in issuance of notice in appeal.
My lord.
Appeal is to be admitted.
My lord.
Whether we admit it or we don't admit it.
My lord. My lord, in that case, my lord, may I pray? I have consumed much time of your lordship. Maybe on some other day, my lord, let me say something. If your lordship give me some option. Let me examine further on. It may not be dismissed. If it is not admitted, my lord, it may not be dismissed today itself, my lord. Let me give some sign.
So we take it up on Friday then.
Friday, my lord, I will not be available. I am going to Chennai, my lord. So some other day, after 2nd of June, my lord. I am to go to Chennai.
Here we start with the. Can we shake on the I apply this again on 4/6/2026.
Master.
Minutes, 6 and 4 June. It happens to be very urgent. Fourth, let me see. 4th June. Bona fide requirement, degree was passed on bona fide requirements. So. This case is also pending your office. execution case is pending and the executing court has passed the order that they will not inclined to pass any order till this court passes order. So executing court is not willing to pass any order till this court pass any order. So until and unless this court passes order, the lower court will not take up the case.
What is the date? 4th of June, no adjournment. So it's represented. Consent of the transfer for both sides. The next date of listing is fixed. Accordingly, no adjournment shall be granted on the due date of listing. And the matter will be just on 4/6/2026.
And brings for date in item 7.
Let the court counsel have to do it because there is another bench right now. Date, fixed dates may not be available for all cases, but in all matters we'll see in fixed dates.
For orders, item 1, review petition 60/2026.
May it please the lordships. Yes.
My lord. The ex parte order was challenged by the petitioner, my lord. That was passed a long back, my lord. Ex parte order was passed on 10/5/2018, my lord. That was challenged before this honorable court, and this honorable court, my lord, was rejected that petition on the ground of delay. And my lord, being aggrieved, my lord, petitioner approached honorable Supreme Court. And the Supreme Court, my lord, disposed of the petition with the direction annexure 5, my lord, at page 85, to file a review petition before this honorable court. And accordingly, my lord, this review petition has been filed, my lord. Lord, kindly see the page 85, my lord, the honorable Supreme Court's order, my lord.
Yes.
My lord, page 85, last line, categorical stand is being taken before us that the petitioner was never served proper notice by the tribunal, and as such, he had no opportunity to challenge the same within a reasonable time. That being so, it seems to us that
Page
the,
68. See page 68 now.
my lord,
Page 68.
page 68.
Order
Yes.
7/7/2018.
7/4,
7/4 maybe 4. Yes.
this is 7/4/2018.
Yes.
Yes.
Notice return after service.
Notice return after service, copy absent without any stay, fixing 18/4/2018 for appearance. 18/4/2018, OP absent without any stay, fixing as
But notice is served as per.
notice is served.
Yes, notice is served. My lord, what happened in this case? Notice served petition on the petitioner, but my lord, notice was served on my lord 17/3/2018, my lord. 17/3/2018. And my lord, just after my lord few days, that is 3 days, the petitioner was arrested, my lord, in connection with the Prohibitions PS case, my lord. And that's why, my lord, petitioner,
We stopped you at a particular place when you were reading Supreme Court order.
my lord,
There you say that petitioner was never served proper notice.
proper, no, never serve proper notice. My lord, proper,
Service of notice, then you are arrested for two different things.
my lord.
So once you have been arrested, then you may have a difference for coming out later than giving a statement, or somebody could have taken time. But the Supreme Court was on the return on the premise that it was never served.
My lord, interpretation, my lord, I am going to say, my lord, that proper notice, my lord, if I gone through the notice, my lord, then it is, my lord, it is mandatory to write in the notice that the petitioner, the burden is upon the petitioner to prove that he is not a foreigner. That line should be given in the notice, my lord, but that is missing in the that notice, my lord. So, my lord, in that point of view, my lord, I beg to submit that it was not a proper notice served upon the petition. So, my lord, I beg then an opportunity may be given to the petitioner, my lord, to submit his documents to prove that he is a citizen of India. And my lord, it is clear, my lord, the full bench decision, my lord, State of Assam versus Mondal, Muslim Mondal, my lord. Paragraph 103.
Petition and annexed hearing. Writ petition is annexed hearing.
Writ petition, I have.
my lord, 2013 1 GLT, page 809. The 11th page, my lord, 860. Paragraph 103. Paragraph 103. 1 GLT, 2013 1 GLT 809 page. State versus Muslim Mandal.
But Mr. Day, there is a stipulation in the notice that if you want to prove the allegation is untrue, and that you are a citizen, you have to come and prove.
Yes.
See that the stipulation is that যদি আপনি আপনার লোকে পরোক্ষ অভিযোগ অবাধ্য আর ভারতীয় নাগরিক বলে প্রমাণ করিব খুঁজে তেনেহলে so he has to prove it.
I thought specific line is should be that burden is, my lord, paragraph 103, Roman 3, my lord. Notice shall be issued by the tribunal in the official language of the state, also indicating that the burden is on the proceeding to prove that he is an Indian citizen and not a foreigner. That is to be specifically mentioned, my lord. And I have gone through some of the notices in other tribunals, my lord. It is specifically mentioned. Under section 9, it is your burden to prove that you are not a citizen.
Only that burden what is not there.
But that's why, my lord.
আপনি যদি প্রুভ করবে বিচারে
This is expert word, my lord. It is in common. It is written that if you fail to appear, then it is decided.
not fail to appear. He said if you want to prove yourself as an Indian citizen, come.
I can show your lordship, my lord, another notice issued by other.
Yes.
My lord, as your lordship has laid out, my lord, it is clear. In fact, my lord, 1964 rules para 3. Yes. Order 1964. order 3. Rule 3. 64 order 3. My learned senior friend is relying on para 4, but the first one, my lord, para 1. 3.1, my lord. The tribunal shall serve on the person to whom the question relates a copy of the main grounds on which he is alleged to be a foreigner and give him a reasonable opportunity of making a representation and producing evidence in support of his case, and after considering such evidence as may be produced, and after hearing such person as may be desired to be heard, the tribunal shall submit the opinion to the officers or authorities specified in this behalf in the order of reference. That is the first point, madam. The grounds has to be given and a reasonable opportunity has to be given. Now my learned senior friend is relying this para 4, madam. That cannot be read isolately, madam. Then para 2 says, order 2 says, foreigners to serve a so-called notice on the person to whom the question relates. That is the proceeding. The notice referred in subsection 2 shall be served within 10 days on the receipt of the reference of such question by the central government or any authority, competent authority. The notice shall be served in English and also in official language of the state, indicating that the burden is on the proceeding to prove that he or she is not a foreigner. That is enough, my lord. That as my learned senior, my lord, your lordship has read out the notice. Notice is enough, my lord. At that notice, my lord, if it, my lord, goes, it's not a preventive detention, my lord. My learned senior friend is probably relying on as per the preventive.
No. It is as per full bench decision, my lord. I am
this is not a preventive detention, my lord. This is a notice whereby, my lord, whether by that notice any prejudice has been caused to her or him. Notice is, my lord, just only for giving an information that there is a case pending, and if you want to prove it, prove it. That is the language what is there in the, my lord, notice. If you want to prove it by yourself. Probably the notice, my lord, if I may go through the, my lord, notice. This is purely technical issue, my lord. If this way, my lord, the authority has to consider. And what is there in the, my lord, earlier repetition? Earlier repetition, my lord, if I may go through. The earlier repetition, my lord. Please.
My lord, my ground number 4 and 5 may also take into consideration.
My lord, the Honorable Apex Court, while giving the while remanding the matter, has clearly stated the petition, my lord, for the fact. There are page 85 number 2. The point number 3. There are 2. A categorical stand is being taken before us that the petitioner was never served proper notice by the tribunal, and as such, he had no opportunity to challenge the same within a reasonable time. That being so, it seems to us that petitioner should raise such factual issue before the High Court in a review petition. This is not a factual issue, madam. this is in fact a legal issue. Well, whether in the notice that should contain or not, that is not a factual issue. Well, that is not a factual issue. That is a legal issue which is to be determined. They are not on that. Their main question is well, contention there in the apex court is that notice was not proper. They never served proper notice by the tribunal. That is the point. And in this regard, my lord, in page 30 of this review petition, there are 15 the writ petition, what they have stated, man. If your lordship may kindly see, there are 15 what they have stated before the honorable court during this petition. Review it is there, mother, page 30, review page 31. Yes. Writ petition is annexed here, man. It's a part of the writ petition.
Part of the
Review 15, yes. There are 15, it is said, man. It is that the petitioner expressed that the notice was served upon the petitioner on 7/3/2018. They have clearly stated notice was served upon the petitioner, but he could not appear before the tribunal on 7/4/2018 as he was in jail house. This is the one of the pleadings taken in the writ petition. However, in the order it is showing so fast by the learned petition. So it is not the case that notice was not properly served. That is the factual aspect, whether notice was properly served to him or not. Whether the notice was served to him or not. That aspect. Otherwise, whether the notice is valid, the language of the notice is valid, that is a legal question. That is not a factual aspect. That is a legal question and a question of law. That was not the question there. My understanding, that was not the question before the apex court. Yes. Yes. Already, SLP को भी तो SLP को order. This is order.
Order copy में
Order is here.
SLP copy है.
So my submission is that the notice was properly served. That aspect, there is no dispute.
Roman 3. There are 103.
What happens when you bring law? What happens when you bring law? That provision you say, that notice has to be served in English or any of the regional language, correct?
Yes.
Now, come to page 11, para 3.
Of the petition member.
No, of this review petition?
Yes, yes. Okay. Page 11 now, para 3.
Yes. Now, it was the duty of the tribunal to issue fresh notice in English and Assamese language. They need some notice in English. He will read Assamese and English and then understand.
Yes.
My lord.
Okay.
Times when we were young, they could not understand, so we had this Hindi and English dictionary.
My lord, this is the provision.
Converted to Hindi and then we understand. Those are wonderful days. Bhargav dictionary, I still have it. Okay, we'll examine and pass orders.
Yesterday from second June for passing on. We'll take some time to go. The deal on account for the petitioner. As well as also for the respondent. Matter has been brought. Response to second June of the given. GLT. It of 2021 GLT 809. You can print out over the tax book. Page 103. One of the paragraphs, whatever it is, you can print out over the tax. Paragraph 103 GLT tax. And if you're obtaining Supreme today, it would be 102 here. If you're obtaining a Supreme Court. Will you have GLT? Only of that page, don't take other pages. The volume is order, so we don't need that. Make 2 copies and give 1 to each of us. Whoever is the CGC and other conflict, please keep the names.